Okay. Good morning, everyone. If you could take your seats, we're going to get started here in just a moment. I'd like to welcome everyone to this informational hearing on 2009 Delta and Water legislation. This is a joint hearing of the Assembly Water Parks and Wildlife Committee and the Senate Committee on Natural Resources and Water. Co-chairing this hearing with me is my colleague, Senator Fran Pavlik. And just for some opening housekeeping items, again, this is an informational hearing on the Delta and Water package. This is not the last hearing. There will be a second hearing at which we will take up other items, including specifically the financing piece of this package. Today we're going to focus on a few of the policy and governance issues. And the agenda that most of you have has changed a little bit. We are going to start off by taking Senator Steinberg, who will tell us a little bit about how the policy and governance package has evolved since we left off on September 11th. We had hoped to have a water stakeholder panel on the agenda. Frankly, in putting that together, we realized that it's tough to decide which stakeholder should be on that panel. So and given that we have limited time, the Assembly has a session at noon, we decided to scratch the stakeholder panel. Instead, though, we'll be hearing from these stakeholders during public comment. So we will begin with Senator Steinberg. We will then go into the issue panel. And Senator Steinberg, welcome. Also, I want to point out that we're joined by several colleagues who are not committee members but have nevertheless been very active in the water issues. My colleague Mike Fuhr and Ira Ruskin among them, and I expect a few others to join us as well.
Good morning, Mr. Chair and Madam Chair. Let me begin by thanking you and your incredible staffs for all of the hard work, not only that went into the preparation for this hearing, but for your work throughout the year as we have attempted and continued to attempt to craft necessary and vital legislation for California's water future. I also want to thank the members, and rather than introduce or thank you all by name, let me just say that there have been a number of members who have been involved in these issues for many years, who have laid the groundwork, who have been trailblazers, and we would not be here today on the verge without your work and your support. I have a PowerPoint here, and this is, the 21st century after all, and I was once a professor, so there, and a lawyer. That's correct. But the purpose of going through a brief, hopefully relatively brief PowerPoint is to not only review the provisions of the bill, which is now SB 1-7X in the seventh special session, but also to point out the differences between SB 1-7X and SB 68, which was the bill that was before the House, not voted upon as we adjourned on the 11th of September, because I think that's the key thing that members of the public and obviously the members of the legislature want to know, and that is, how has the bill changed? How have we addressed concerns? How have we dealt with the myriad of controversies that surround such a large change in California's water policy? So if we can begin with slide 1. Who's operating this? Yeah, I can. Which one is this? On the right. Okay. Good. I'd be glad to get anybody water, too, if anybody would like any. First of all, though this is not a hearing, I understand, in which votes will be taken, so technically we're not dealing with authors' amendments. I did put up this slide because I do want to review with you that there are still some drafting issues that we are dealing with, and we do plan to amend the bill to deal with some of the drafting problems. For example, the bill has a member of the Delta Protection Commission as an ex officio member of the Delta Stewardship Council. That's not the intent. That's a drafting error. The DPC ex officio member, we will amend that to make that person a permanent member, because that was the intent. We also clarify language regarding membership of the Delta Protection Commission to ensure that the north part of the Delta is adequately represented. We continue to tweak the Water Code Section 375 clarification dealing with existing local ordinances around conservation. We still have some language to consider and to get right around covered actions in the Delta secondary zone. The concept at this point is that we would exempt those lands that are consistent with Senate Bill 375 from last year, the Greenhouse Gas Transportation Act that I was privileged to author. We have some minor changes on wastewater mitigation language as it affects the Sacramento Regional Sanitation District, and some other technical amendments.
Senator Steinberg, just there is also some, I guess, some additional language that's supposed to go in the urban water retailer water supplier section near page 61 that the Met and San Diego County Water Authority and others had the understanding that it would be in. So I guess it's a little drafting error.
That's added to the list as well. Thank you. Under the catch-all of other technical amendments. No problem. Background context. You know, even though we have been through this together many, many times, I do think it is worth describing again what this is about, why this is so important, and why there is urgency. The Sacramento-San Joaquin Delta, which is the heart of the state water system, is one earthquake, one flood away from collapse, and 24 million people could potentially lose their drinking water. The state water supply is obviously changing for all the reasons we know. There's our supply issues, but we also need to manage water more efficiently, stop water theft, manage our groundwater resource more efficiently, and provide options for conveyance and for storage. And as we all know, this is, depending on your perspective, 3 to 5 decades in the making. The legislature has attempted to grapple with these issues for many years and unsuccessfully. Now is our opportunity. There's been a lot of questions about public process, and I just want to state the facts once and then move on. In the past 10 months alone, there have been at least 2 informational hearings, 4 policy committee bill hearings on each of the bills within SB 17X, 4 appropriations committee hearings on each of the bills, 2 conference committee hearings, and 5 floor debates and votes on provisions of these bills. That's in addition to the Public Policy Institute report of 2007, the Delta Blue Ribbon Commission report of 2008, Assembly and Senate committee informational hearings early in 2009, and though they weren't public, the leadership sponsored bipartisan bicameral working groups that met for months this year. All of the proposals embodied within SB 17X are based upon the governor and the legislature's 2008 Delta Vision Task Force report. The focus, of course, is on fixing the Delta, new governance, funding, and protections to improve water conservation by 20% by 2020, to stop water theft, to protect those who have legal rights to water, to better monitor and manage our groundwater use, and to provide financing for key water system improvements. And I want to reiterate what Assemblymember Huffman said a moment ago. The legislative leadership is meeting with the governor this morning to finish a proposal, emphasis a proposal, on a bond. That's no secret. And we all know that we are working to have a comprehensive package. So do not take the fact that the bond isn't in print yet as anything more than the fact that there is still, there's still a little bit of work left to do. On fixing the delta, this is the key here. The bill, of course, provides for a new governance entity known as the Delta Stewardship Council. It provides for a new conservancy. It amends the Delta Protection Commission. It employs a science review panel, which is key to making sure that the decisions we make are based on science, not on politics, and a water master with authority to help ensure that the plan is adopted in a correct way. The new plan, the Delta Plan, is not only what's called for in the Delta Blue Ribbon Task Force to ensure that the co-equal goals of water supply reliability and restoring the Delta ecosystem, all consistent with maintaining the Delta as an evolving place. The Delta Plan is the document, if you will, the living document that will be put together by the Stewardship Council that will be the steward and responsible for the achievement of those co-equal goals. The bill, of course, maybe the most important part of the bill, and people have different perspectives on this. We all know that the Bay Delta Conservation Plan is moving down the track. And so those for or against a canal, I think most people would agree that the Delta Stewardship Council, for proponents, provides a more stable process and a more understandable process to get to a decision as to what is the appropriate thing to do with conveyance around the Delta, through the Delta, combination of through Delta, around the Delta. The BDCP is on its way. Without this sort of overriding structure that provides some coherence and governance, many people say that the BDCP itself could get tied up in litigation for years, if not decades. From the other side, those who are concerned that the BDCP is a fast train moving down the track, the Delta Stewardship Council is a check, because its fundamental authority is to ensure upon appeal that the BDCP is in fact consistent with the co-equal goals of restoring the ecosystem, maintaining water supply reliability, all done in a way that is respectful and considers the Delta as an evolving place. The bill as well provides for the highest level of CEQA analysis known as for the BDCP known as an NCCP, all these acronyms here, but a higher level of environmental review before the BDCP can even be certified. Next slide. The bill, of course, also contains the key elements of the Huffman-Fuhr conservation bill.
Actually, it was Fuhr-Huffman, I have to say.
It was Fuhr-Huffman. Sorry, Mike. There goes one vote. There we go.
It was always your favorite.
Yeah. And of course, much of the work of Senators Ducheney and Dutton, SB 261, has been incorporated as part of the compromise. But we do establish a 20% by 2020 water conservation target. It applies to urban and ag water users. There is flexibility for the locals, 4 different pathways, which we can discuss, and the witnesses here can discuss in some detail. And for agriculture, they are required to put together best management practices. We have a specific sanction applied to the failure to meet the goal, which is the loss of state water grants and loans. In other words, the bond which the voters hopefully will pass, future bonds, if you don't meet one of the 4 pathways, you'll lose the eligibility for water bonds. Next, improving groundwater monitoring and management. The fact of the matter is about 75% of the state's water basins already perform groundwater monitoring, but it is voluntary under current law. Most states require groundwater monitoring. The bill requires mandated reporting statewide, but unlike the original version of Senator Pavley's bill, who also has done incredible work moving this forward, the amended bill, or SB 17X, assigns the local water agencies to perform the mandate. The local agencies must submit to the Department of Water Resources for statewide data on the use. And like conservation, there is the loss of grants and loans in the water area for failure to perform. One of the key Republican concerns that we have addressed, and among the technical amendments that, or among the amendments that I've spoken with Senator Hollingsworth about, is to make sure it is crystal clear that even though this is a local mandate, no local government official may enter land or compel reporting without the property owner's permission. So in other words, the local agency has the responsibility. And if they don't perform it, their county, under the way the bill is written, may lose water funds. And so it's going to be up to the local agency to seek volunteers, to use incentives to gain the permission of property owners to go onto their land to be able to measure their groundwater use. It's a compromise, but again, it's a compromise that respects private property rights and at the same time ensures that someone is accountable for getting the information to the state. The other part of Senator Pavley's bill, SB 229, was limiting illegal water diversions. This is key. It's sort of like the underground economy when it comes to labor and employment. Why should those who are following the law be disadvantaged by those who are not following the law? And from a statewide perspective, we are losing potentially thousands of acre-feet of water per year, water that would otherwise be available for lawful urban or ag use. The bill as amended increases reporting requirements. It increases the fines from $500 a day to $1,000 per day for the first offense, $5,000 per day for a second offense, or the market value of water, whatever is higher. The bill also streamlines enforcement, and one of the most important pieces provides 25 new so-called PYs, 25 staff, engineers, attorneys, and others to allow California to be much more aggressive in enforcing our water rights laws. That shouldn't be in there. Here we go. Hold on here. Okay. Change. Where's Kim?
Mr. Chair?
Yes.
Mr. Chair, or Mr. Steinberg, I was just going to ask if, while you're looking at that, will the committee members, unless I've missed something, will we be able to get a copy of your PowerPoint?
Okay. I'm sorry?
I was just asking, since you're looking and so forth right now, would it be possible for the committee members to have a copy of your PowerPoint?
Oh, of course.
Thank you.
Yeah. Although, you remember when President...
Although it would change, right?
Yeah. Well, you remember when President Clinton was giving his State of the Union address, like I think in 1995, and the teleprompter messed up and he had to go off of his notes? We're going to stop the PowerPoint here because it has changed since that version. So I apologize for that. Let me review again the key revision since SB 68 was heard on the 11th of September of 2009. First of all, we have made significant amendments giving the Delta cities and counties greater local control over land use in the secondary zone. If you recall, the Delta Blue Ribbon Task Force called for the Stewardship Council to have jurisdiction over the secondary zone. After hearing from the local representatives, we made some changes, and it's a difficult balance because if you exempt too much of the secondary zone, then you are losing the benefit of trying to provide coherent governance where there are over 200 entities and agencies that currently operate within the Delta and have some authority, and it loses, the Stewardship Council loses some of the the force and impact that we all hope it has to achieve the co-equal goals. So what we did, again, is we said that those projects that are consistent with last year's SB 375 and therefore part of an agreed-upon urban footprint would in fact be exempt. We assured that the West Sacramento member of the DPC remains on the DPC. Key point here, we ensured that in-stream flows do not impair water rights. And this has been maybe among the most controversial issues, and I want to spend just a moment on it, especially from the Bay Area water agencies, the Sacramento water agencies, and the so-called upstream diverters. Here's the situation we face here in California to simplify it. We have more people, both in Southern and Northern California, so it's not just geographical. We have less water. We have a delta that desperately needs more water. And we have existing water agencies and cities and counties with sacrosanct and very good water rights. How do we reconcile the need for more water in the delta, the fact that we have more people and less water, and make this system work? And so we were clear in SB 68 that nothing in the bill impacted existing water rights, and we were specific about pre-1914, post-1914, and other descriptions of water rights. And the Bay Area, and again Sacramento and the upstream diverters, didn't think that that was quite enough. So then we stepped back and recognized the following. If this bill does not go into effect, if all this goes away, under the existing law, the State Water Resources Control Board has the legal authority upon proper petition to hold evidentiary hearings and to determine a change in water rights. That's the existing law. And so we have been reluctant to do anything that would increase protection beyond what the existing law is, because that would defeat the overall purpose of trying to achieve the co-equal goals. But we did come to an agreement with the San Francisco PUC, and we do hope that some of the other Bay Area agencies and the Contra Costa Water District, we do hope that some of the other Bay Area agencies, Sacramento and the upstream diverters, will look at SFPUC's letter of support and look at the language which can be found on page 97 of your printed bill, and see that before there can be any preliminary public trust determinations around the issue of in-stream flows, that there has to be a full public hearing with full public input. And that before any water rights could ever be affected, there has to be the full evidentiary hearing and full process that exists under the current law. Why is this important? Because in-stream flows, frankly, are the key to fixing the delta. To put it in layperson's terms, in-stream flows is about how much fresh water is the delta going to need to restore its ecosystem. And until that determination is made, and until we figure out as a state where we are going to get that water, the achievement of these crucial co-equal goals cannot occur. But again, significant changes, page 97, it's brought on San Francisco, and we hope it brings on the other Bay Area, Sacramento, and upstream entities as well. On water conservation, since September the 11th, the bill has provides greater flexibility to inland suburban water agencies, otherwise known as Path 4. It basically gives the Department of Water Resources 1 year to adopt regulations setting new standards at 20% or below. And the DWR can take into account the impact of climate on particular areas of the state, lot size, and other factors. This meets the strong demand we've heard from a number of agencies saying we need greater flexibility. On the business side, the bill provides greater flexibility for water-intensive manufacturing and research and development activities. We've exempted R&D, and we've made the change on this so-called 375 issue, not SB 375, but an old water code section 375 that allows local water agencies essentially to develop more stringent conservation rules than any state law. We've made some changes to assure that the drought area law, this old 375, cannot be used to impose numeric water conservation restrictions on manufacturers who use water. On the issue of groundwater monitoring, like I said, we made a fundamental shift. We went from a under Senator Pavley's bill, if the locals didn't do it, the DWR would come in and do it themselves. We changed that. Now we under the bill, directs local water agencies to implement the monitoring. Again, it prohibits water agencies from accessing private property or compelling the monitoring information from property owners. And again, the failure to provide the monitoring results in loss of water grants and funds. Here's one nuance and detail, but it's important. Given that there are overlapping water entities, oftentimes within a county, what the bill says is that if a local water agency fails to perform the groundwater monitoring, it becomes the responsibility of the county. If the county fails to do it, it's the county, the overall county, then that loses the eligibility for the bond funds. That's to ensure that there is actually some accountability and responsibility, because you could see the monitoring being done in one water basin but not in another with overlapping jurisdictions, and the one that did it would get the bond funds and it would inure to the benefit of the one that didn't. So this provides, we think, more clear accountability. On the issue of illegal diversions of water, as I said earlier, the Pavley bill increased penalties. In the amended bill, we established tiered penalties, $1,000 for an initial violation, $5,000 for subsequent violations, or the highest market value of water, as a significant concession to those concerned about too broad of authority to the State Water Board. We have eliminated the entire section on interim relief and eliminated the new cease and desist authority. Last but not least, I want to spend a moment on the Delta, and because among the controversies have been, is the Delta adequately protected under this comprehensive legislation? And again, I would remind everyone of the context. If you believe that the Bay Delta Conservation Plan is in fact a sound plan, and there's, controversy over that, but if you believe that is in fact a train moving down the track, then the conveyance that some are concerned about, the administration, the water contractors, and others believe that that process itself will provide authority to take that action. This process ensures that there is a more coherent, understandable, and inclusive process to determine what the right answers are when it comes to conveyance and the Delta. For the Delta counties have complained, right or wrong, I don't make a judgment about it, that they have been excluded, in fact, from the BDCP. And this, again, provides, I think, a legitimate check on that process. But in addition, as you see the finance piece roll out over the next day or two, you will see that there is increased local funding for not only ecosystem restoration in the Delta, but hundreds of millions of dollars for local funding for economic revitalization within the Delta. Legally binding assurances which don't exist now that Delta counties will be compensated for any lost property tax revenue due to actions in the Delta, such as the construction of a new water conveyance facility. Legally binding assurances that cost to upgrade regional sanitation facilities triggered by CEQA mitigation requirements will be borne by those proposing the changes. Strong local and regional representation on existing and new governance entities created within the package. 5 out of 11 Delta representatives on the Delta Conservancy. Again, as I stated earlier with an author's amendment, the chair of the Delta Protection Commission will be a full voting member of the Delta Stewardship Council. More flexibility when it comes to conservation. More legally binding assurances on existing water rights and area of origin rights. Greater local control over land use determinations in the Delta secondary zone. A heightened authority for the Delta Protection Commission to have its recommendations and findings incorporated into the Delta plan if they are consistent, in fact, with the co-equal goals. And so, members, this is a comprehensive package. And as has been said by many, the definition of a compromise, in my view, ought to be the following. It ought to be that there is some things in a package that members and stakeholders either don't like or would do differently. But there are so many more things that members and stakeholders want and need for California to move forward around this crucial issue. And then finally, you know, we all suffer a little bit as legislators and stakeholders and members of the public from what I call negotiation fatigue, right? You sort of have to step back sometimes and say, all right, where are we here? Because the wrong frame, in my view, is to simply ask the question, well, geez, what have I given and gotten over the last month? It's relevant, but it isn't the key question. What have I given and gotten over the last month and a half since the legislative session ended? Instead, I think the right frame and the right question is, if this package were put before the legislature for the first time today, and of course, it's not the first time, as I stated earlier, but for the first time today, combined with the finance package that everyone at least knows the broad outlines of, would you say that this is a dramatic improvement over the status quo? I think the answer is clearly yes. I appreciate your time and be glad to answer questions. There are a number of people here from various walks of life when it comes to the water world who are here to express their opinion about the product before you.
Thank you, Senator Steinberg, and thanks for your hard work on this. Now, would you like to have some of the folks at the table speak
Sure.
to?
And then we can have a discussion.
Great. Welcome. Jeff, you want to start off?
I'll be happy to. Thank you, Madam Chair, Mr. Chairman. Really want to thank the Senator for all his hard work, Senator Steinberg for all his tremendous work on this, and for having a PowerPoint, because now it feels like a Met board meeting when we have a PowerPoint. Really want to thank the committee for all the great work they've done here. I'll be very brief. 2 key points I would like to make. The first is, in the 20-some years I've been working on water issues, this is the best, most comprehensive package I've seen yet being moved forward in this House. And so we really are hopeful that we can get there. This really puts on the path the co-equal goals that was put forward in Delta Vision. This bill's far from perfect. It certainly isn't exactly how Metropolitan would have written it, but it is very, very good, and so that is why our board has come out to be supportive on it. The second point I would like to make is timing. I've heard a lot of people say maybe we should take a little more time to make sure we get it right. We believe the time is now. We've been working in CalFed for over a decade. It's been 3 years or so since Senator Simitian introduced a conveyance bill. We have been talking about these issues for some time. We've been gridlocked on them. There's a couple of reasons why it's very critical to move it forward now. First is the Bay Delta Conservation Plan is on track to be completed in about 18 months. For a seamless implementation of that, we need to have the Delta Council and the Delta Conservancy with appointments made, gone through the hearing process, had the Senate confirm those appointments, and get it up and running so that we can begin implementing it. Failure to kind of do that over the next 18 months will set back the Bay Delta Conservation Plan and just put further and further out any chance of a reliable water supply. Secondly, that's a very critical point that I think a lot of people have missed, is our agencies. We are preparing urban water management plans as mandated by state law, all have to be completed by the end of next year. Those plans will be looking at, can we say in those plans that California has a reliable water supply for the next 25 years? Is there a plan in place to fix our water supply? If not, those urban water management plans will say water reliability is perhaps up in the air and we don't yet have a plan through the legislature on how to fix that. If we can't say that we have plans to have a reliable water supply, we're going to cripple any chance of an economic recovery. And so that's why it's very important to have this in place now so we can draft those urban water management plans that can put us back towards economic reliability. Thank you.
Mr. Chairman, I apologize. Just in the off chance that there are people that don't know who Jeff is, would you just identify yourself for the record?
I'm sorry, I thought I did that. Jeffrey Keitlinger, General Manager, Metropolitan Water District. Thank you.
Good morning. My name is Ann Nothoff. I'm with the Natural Resources Defense Council, and NRDC has been focusing on this policy package of water bills. As you know, we've worked in the courts and the legislature and in local jurisdictions across the state to improve California's water management. And we think that it's been possible to develop this bill now because of the broad recognition that California must turn into a new direction to address the complex problems in the Delta. The drought has increased the urgency to deal with this, and we need to save California's salmon fishery, and we all recognize that we need to provide a more stable and reliable source of water for Californians and our agricultural and broader economy. And NRDC has been the co-sponsor of AB 49 and before that AB 2175 with Mr. Fuhrer and Mr. Huffman, and I wanted to focus a little bit of time on that. We think that this version of the bill maintains the essential requirements of the conservation component, and of course we think that conservation needs to be a cornerstone to any real California water policy. The bill maintains the 20% reduction requirement, and it also provides a flexible way for districts to meet the requirements while giving credit to districts have made considerable investment and have achieved good conservation already. So we, along with a broad range of interests in California, do identify conservation as probably the biggest pool of water for new resources here in California. As we finish the negotiations on this bill, I think it's very important that we do not lose any of the ground that we have made so far. And I think especially when it comes to the conservation element, we need to maintain the constitutional protections that we have in California and on water law and not roll back any of that or any, I think there have been proposals that we've heard that would do harm to existing law, and we are dead set against any approach like that. I also wanted to just emphasize the importance of acting now. In addition to the fact that the BDCP is rolling along, many people don't recognize the fact that some of the protections that we have now in place in the Delta, whether it's from federal or state orders, are really quite fragile protections. And having a good, solid plan in place here in California is very essential to maintaining the kind of protections that we need and to moving forward. So in closing, I just want to say that we too acknowledge that this is a very complex set of compromises. It's not a perfect bill. There are pieces that we would have written differently had we been king of the world, but alas, that's not so. And we think that but rather than being a timid lowest common denominator type of approach, it has maintained integrity, and it is in fact broadly supported because it does represent real fundamental change and will pave a path for a much more solid and reliable water future while protecting our Delta ecosystem. Thank you.
Thank you. Mr. Gastelum, you want to identify yourself and then
Yes.
Jump in?
Good morning. My name is Ron Gastelum. I'm here today representing members of the REAL Coalition, the Bay Area Council, the Silicon Valley Leadership Group, the Orange County Business Council, and the Los Angeles Area Chamber of Commerce. Water is one of our top priorities, along with education and transportation. I'm also on the LA Area Chamber of Commerce Board of Directors and the Executive Director of the Southern California Water Committee. We've been alarmed at the worsening position on water in California for some time now. We are environmentalists. We have a tremendous number of agricultural interests within our midst, and we are businessmen. We are very, very appreciative of the work that's been done today by all of you and by the various interests in forging this package that's before you today. I've been in water resources for the last 30 years. I am a water lawyer. This is not a radical package. This is not a major change. This is hones to our basic principles in California of water management. But we are setting the right direction at a critical time, and it strikes a fair balance between the many competing interests. Of course there are opponents. We are changing the status quo and setting a new direction, but the status quo is not sustainable. The business community absolutely gets it. The Southern California Water Committee was formed to promote a peripheral canal 25 years ago. That is not who they are today. They have matured to the point where we are advocating conservation, water rights, groundwater management, and a Delta fix. We urge you to go forward with this package.
All right, thank you. Mr. Manning?
Thank you, Mr. Chairman and members. Ed Manning on behalf of Westlands Water District and Tom Birmingham, General Manager of Westlands. We come at this issue from a slightly different perspective. As many of you know, Westlands and the west side of the San Joaquin Valley have sort of been the canary in the coal mine in terms of the severe impacts of lack of water supply reliability. Right now, we have several 100,000 acres of land fallowed, almond trees, pistachio trees plowed under for acre after acre after acre, and west side communities that have unemployment in the 20, 30, 40, and 50% range. Mendota running out of money for a food bank, and on and on. So I don't think any communities have seen the impacts of lack of water supply more so than on the west side. We've been working on a bipartisan basis for several months now, day and night, as many of you can attest to try to get to a package that's balanced. For us and our perspective, we've been testifying in the informational hearings since the beginning. We came to this with a couple important goals. One, that the Bay Delta Conservation Planning process, which has been ongoing for several years, convened by the Schwarzenegger administration, be able to proceed, and that the integrity of that work product, which includes anyone who wants to participate, would be protected and, in fact, enhanced by this legislation, and we think it meets that test. Second, that any package would provide a clear path to conveyance, so that if the BDCP is adopted as a Natural Communities Conservation Plan, that the BDCP would be able to be implemented and begin restoration of the Delta, and with that, have a clear path towards building new conveyance, and we think it meets that test as well. Finally, we wanted to make sure that the package was balanced and that the new governance structure would be balanced in a way that it would be able to act as an appellate body for certain things while not being able to micromanage other significant things such as the plan, and we think it meets that test. There are too many amendments and details for me to cover that have even in working with Chairman Huffman in the last several days to try to address concerns of various parties. But safe to say, I think we are happy with the package, and specifically the Delta piece the way it is. We are supportive of it and happy to answer any questions. Thank you.
All right. Thanks, Ms. Kohler.
Members of the committee, I'm Cynthia Kohler with the Environmental Defense Fund, and I'm here today authorized to speak as well for the Bay Institute of San Francisco. I'm going to mainly agree with my colleagues. We've worked hard on this with your committees, with your staff. We appreciate very much your time, your energy, in particular, Mr. Pro Tem, yours, and yours, Chairman Huffman. I will add just that, in our view, the strength of this package is its comprehensiveness. Like Mr. Keitlinger, we would have written a somewhat different bill, but we have very much appreciated the good faith efforts of our colleagues here, and we think we have come up with a package that is as I say, comprehensive, and that does move us forward in some key directions. And rather than enumerate all of those now, I will be happy to answer your questions. I will say that there are a few things in the bill that emerged on Friday that we still think need to be cleaned up a bit, as I'm sure everybody does. But for the most part, we are very much hoping that we're able to move forward in a timely manner, because I very much agree with the points made here today that the time really is now, given the crisis in the Delta, the crisis for our salmon fisheries, and the speed with which the Bay Delta conservation planning process is moving forward, either with or without legislative action. Thank you.
All right, thank you. And last, but certainly not least, Senator Steinberg, you've got a new face at the table in the group of parties that
we
you've been
welcome
working.
everyone. Come on.
We'll get to everyone, but right now we have Don Gilbert.
I feel the love. Mr. Chair and members, Don Gilbert representing the San Francisco Public Utilities Commission. We're in support of the bill. We engaged in extensive discussions with the Pro Tem and his staff, and Mr. Chair, with you and your staff over many weeks to try to reach an equitable compromise on some of our concerns, and we're happy to report that we did reach that compromise. So for that reason, we support the bill. Thank you very much.
All right, very good. Well, I think at this time I want to open it up to questions from the committee members of Senator Steinberg and or his eclectic group of parties that have been working on this major bill. Senator Wolk.
Thank you. Quite an array of folks today. I wanted to start by just making a couple comments about the Delta counties and the partnership that they hope to effectuate here. They have, from the beginning, looked at this policy coupled with financing as a package. And they were interested and remain interested in three areas: representation and assurances, that is, as this moves forward, recognizing that potentially it is the Delta that will experience the most change. The assurances about how much water will remain in the Delta, all of that, as a major river is diverted into a canal. That was important, as well as funding. So they had a package of concerns, and they looked at this as a whole. I'd like to focus on just a couple things. They agreed at the beginning that they did not need to have a veto over the canal, which is extraordinary considering the size of it and the impact it will have, provided that they had this representation, assurances, and funding. They also did not need to have a majority on any of the organizations that are being put together, the council, for example. But they needed to have a voice. So I want to focus a little bit on that issue. The council, as originally conceived by Delta Vision, was to be fairly strong and was to have authority to be able to say the canal goes or it doesn't go, that the BDCP is sufficient or insufficient. It was a strong body. And it was also to coordinate many of the other processes and actions that are going on in the Delta. My concern with this is that the council has become weaker. That, as I read the language, Darrell, once the BDCP is incorporated into the council, I guess it'd be easier to ask a question this way. Let's incorporate, the BDCP is incorporated into the plan. Does the council have the right to say, no, we take this, but not that? This works, that doesn't.
The answer...
Who decides?
Sure. Let me again explain the process, if I may. First of all, on the council itself will be, in terms of a voice, there will be one permanent member of the council who chairs the Delta Protection Commission. In addition, as we've talked about many times, the legislature, both the Assembly and the Senate, will retain and have appointment power ourselves. The governor has 4 appointments, subject to Senate confirmation, 2 legislative appointments, and the DPC chair is a permanent member. Here's the process. When the BDCP is completed, it is then essentially sent to the council. And upon an appeal from anyone, broad standing, any Delta supervisor, a Delta senator, a Delta council member, a Delta citizen, that person can appeal the intent to certify to the Stewardship Council itself. The council will then have the authority to determine whether or not the BDCP is in fact consistent or inconsistent with the Delta Plan. And of course, the Delta Plan has the obligation to articulate and lay a pathway for the achievement of the co-equal goals: water supply reliability, ecosystem restoration, both taking into consideration the Delta as an evolving place. And if the council determines that there is inconsistency, it then has the authority to send the BDCP back for more work. It's sort of like an appellate court that can overturn a decision, but then doesn't make the substantive ruling itself. It sends the case back to the trial court for more work consistent with its opinion. And so where we disagree some is that while the Stewardship Council certainly could be stronger, again, you've heard the product of difficult political compromise here. We could have given it overarching authority to have a de novo review, to eliminate subordinate agencies. We could have done a lot of things. But what we put together here that has garnered significant support is a process by which a simple appeal can be taken to the Stewardship Council, and then it vests the Stewardship Council with full authority to determine consistency. That's strong to me.
But it also says that the Department of Fish and Game is the one that's going to determine that the adequacy, essentially, of the BDCP.
No, of the EIR, of the CEQA document.
Actually, of the NCCP.
The NCCP. It's the NCCP. That's correct. See, here's the thing. It would be one thing as well if this legislation said the Stewardship Council has this consistency determination, but all other rights of project opponents are wiped out. It says nothing of the sort. In fact, the environmental review for the BDCP is enhanced by virtue of the bill from an HCP, which is a restoration standard, to an NCCP, which is a recovery standard. That's one. Number two, the bill requires that the NCCP be much more specific and prescriptive in analyzing various conveyance solutions. That currently doesn't exist. It does not negate in any way the ability of a project opponent to appeal a NCCP or CEQA determination, full right to go to court. And then in addition, not as a replacement, in addition, we have this process by which a new governance entity, which doesn't exist today, has the right to say, no, your BDCP is inconsistent with the co-equal goals, and they have the ability to remand it back. That's additional protection. It's not a replacement.
Once the BDCP is incorporated into the plan, its permit will last for 50 years. Is that not correct? Yes.
That's correct, yeah.
All
That's
right.
but after the NCCP.
So,
Right.
let me.
Yep,
all right.
go ahead. Sorry.
3 years from now, 3 years from that date, 4 years from that date, 10 years from that date, the fish are dying. What happens? Who has the power to change that BDCP?
Well, of course, the whole purpose here is to save the fish that are already dying. It's not as if the worry ought to be that this comprehensive set of improvements will make the environmental situation worse. It's already as bad as it can be. The fish, in fact, are dying. But look, in any process involving CEQA or in this case an NCCP, once you have gone through the legal process, and of course the process can be held up for years through lawsuits and other regulatory delays, but once that approval has been given, think about it in the housing context. Approval is given, the house is built. You don't then say, well, 3 years later, geez, what if you decided that you would rather have the subdivision built somewhere else? This is what the process, and you want to put as much protection into the process as possible up front.
If I could, by way of clarification on that, Senator Steinberg, I think you've got a technical question there about if an NCCP or the HCP permit that would be its companion permit proved to be based on wrong information or new information arises after they're granted, are they etched in stone for 50 years or can they be revisited and reopened based on new information? You've got a couple of lawyers there, and so maybe we could, I think Senator Wolk is seeking an answer to that question. Is there flexibility to reopen these permits if necessary?
Senator, just to maybe answer a technical question, EDF is sitting on the steering committee for the Bay Delta conservation planning process, and my understanding is that the answer to your question is, what do you do if, notwithstanding the finalization of that plan as an NCCP, the environment is still suffering and the fish are still dying? I believe the sort of short technical answer is that BDCP is going to have incorporated within it an adaptive management program that is intended to sort of evolve over time. But for purposes, I think, of this legislation, that is the case whether or not this bill passes and whether or not the Bay Delta Conservation Plan is ever incorporated into the Delta Plan. BDCP is required to have an adaptive management plan that responds to those concerns over time. So I don't know that changes whether or not it is or is not inside the Delta Plan.
Right, and then that's the answer. Adaptive management is there is built in within the NCCP the ability to change, to adapt to the needs of the environment. Okay. And that is the way the NCCP statute was written, a strong environmental statute, I would remind you, because it is a statute that provides for recovery, not just restoration of the species. And so nothing here is permanent, but this lays the foundation for being able to go forward and restore the ecosystem, the current broken ecosystem.
All right. Senator Wolk, you had another question?
I do. I have a couple more.
Okay.
All that you described and all that's in the language with respect to the BDCP hasn't really changed since
September 11th.
Right.
Correct.
And the reason I raised the question is that the Delta Vision Foundation raised the issue of a weakened council, a concern about a weakened council. I think what I'm trying to get at Friday night, Saturday morning, and later is what has changed to make the Stewardship Council stronger? And they also talked about the authority of the Delta Protection Commission and a number of other things. So I want to know what makes it stronger, not weaker.
First of all, I mean, I look forward to hearing from Mr. Eisenberg, the chair of the Blue Ribbon Task Force, to opine about the balance here. There were no more significant changes made to the Stewardship Council since September 11th, but our disagreement and my strong opinion is that the council language as of the 11th of September is in fact strong. It's in fact strong because it provides this additional layer of protection, a consistency review, that doesn't exist in law today. Right now, your resort, if you oppose the BDCP, is to go to court and file an environmental lawsuit. This is an additional protection without replacing those current rights. And so it hasn't changed since the 11th, but given the complexities of this issue and given given who you see here at the table and the importance of putting together a robust political coalition in order to move this forward, this is good. It's beyond good.
I'd like to ask a question of Mr. Manning.
Please.
Okay. Mr. Manning, I'm curious. You made the very strong point about the drought and what that is doing in the southern part of the San Joaquin Valley. I'm curious what in the package before us would result in a change in that circumstance. How do you see that happening? What specifically in this package is going to move that forward, which I think is a serious issue?
Well, after Mr. Steinberg's comments, I'm revisiting in my mind why we're supporting this, but I'm revisiting why we're supporting it. I
See how hard this is?
I think the reality is that in the short term, there's nothing in this package that is going to help Westlands in the next year, 2 years, 3 years. The Obama administration and the Schwarzenegger administration are collaborating on some short-term potential fixes. There's the Two Gates project. There's the National Academy of Sciences reviewing the work that was done, the most recent biological opinion.
Two Gates is in this package.
Yes, it is.
Okay.
So. Yeah, and you know, but in honesty, Two Gates, we don't know what benefits are going to result from that yet. We're obviously hopeful that it'll provide some short-term marginal benefit. So, in answer to your question, there's nothing in the short term that's going to help Westlands, and we hope that we get some rainy years and our folks can hang on long enough to survive. In the longer term, we are optimistic and hopeful that the BDCP will get through and be certified as an NCCP. By the way, I think we are glossing over too quickly. There was an enormous risk taken by the state and federal project contractors to agree to the NCCP mandate, because at this point in the BDCP process, we're not certain we can meet it. We think we can, and we hope we can, and we're going to strive to. So the benefit for the West Side is that there'll be a clear path to conveyance. We will have water supply reliability down the road. Perhaps we can get more, as Mr. Keitlinger said publicly and privately, we share the goal to get to pre-Wanger flows, which are less than, obviously, the full contract entitlement, but provide some more reliability so we take out some of the wild swings in water supply in the future. But I think that's the best we can hope for. But it's a heck of a lot better than the status quo for us.
All right. Thank you, Mr. Manning. I'm sure we have some other questions and members, and we've also got another panel that we need to get to before a noon session causes us to leave the room. So let's make this the last question, Senator, if you
I
would,
wanted
please.
to ask Mr. Keitlinger. The estimates about the cost of this, according to East Bay Mud and others, ranges as high as $78 billion, somewhere around there. I'm just, how is this going, the cost of the canal and its mitigations, all of them, provided we have the right language in the bill, are going to be your responsibility. How are your retailers going to pay for that?
Thank you, Senator. The costs are not just metropolitans, I would add. All the state and federal water contractors have agreed that they will share those costs for conveyance and its mitigation. The current estimates, and we're still only about halfway through the environmental review process, so we are currently working, we will refine those estimates, are in the $6 to $12 billion range. That is a very significant amount of money, obviously, and it's very significant impact to ratepayers. It will be somewhere in the range of $70 to $110 increase an acre foot of water. That's pretty significant. For my ratepayers in Southern California, we are talking 10 to 12% increase in their water rates, which is obviously difficult during this period. But for agricultural water users, many of them are looking at 50 to 100%. They are all committed to seeing this process through, and the reason is because we don't have a lot of choice. We either pay for it or we don't get it at all, which means we really pay for it. Thank you.
Mr. Chair, I understand that you want to move this forward. We have not had I would like an opportunity to ask a number of questions about these bills and about the bond as it comes forward.
Yeah.
Is it your intent to have hearings at which that can be done?
Absolutely.
Amendments can be discussed?
On the and on the finance issue, which you were just asking about in particular, as I said at the outset of the hearing, we're going to have that on the agenda for the next hearing, which may be later this week, maybe early next week. We're still trying to work that out. I'm sure by the end of today we'll have that decided. And I think there will be ample opportunity to both hear from authors and witnesses and also ask any questions you have on finance.
Since there's been so much discussion about conveyance, I just feel compelled to point out to the committee that the bill does not authorize a canal. Right. In fact, the bill establishes a set of environmental parameters and requires a full set of alternatives and in-stream flow determinations in the analysis of any conveyance.
Thank you for that clarification. Other questions of members? Senator Pavlik.
I had a question. First of all, I want to thank you, President Pro Tem Steinberg, for all your work on this and trying to hold together a comprehensive package, which was my goal at the beginning. And hopefully we will have another hearing next week, and I will coordinate with Assemblymember Huffman
or this week.
Yeah, this week, and perhaps on Wednesday. But financing will be an ongoing issue, short term, as well as how we pay for the Conservancy and the work on the council, Fish and Game, the 25 PYs for the State Water Board, Science Panel, and the list goes on, because we know the problems with CalFed. One of the problems with CalFed is over-reliance on bond monies, and without the support of the other two members of CalFed, agricultural and the federal government. The problems with CalFed are well documented. But Ms. Kohler with Environmental Defense Fund sort of left out suggested that she wanted to be asked a question, and it was on a topic that I found very relevant for a variety of reasons. You said there were some areas of cleanup needed in this package. Could you just briefly articulate for me those areas?
Sure, Senator. Thank you for asking. As was alluded to earlier, there's been a lot of conversation about the provision that directs the State Board to do an in-stream flow analysis. And I think that just needs a little bit of cleanup at this point, because there are many, many savings provisions in the bill to protect water rights and to ensure full process before any change in water rights. And in fact, the bill does not call for any particular implementation for those flows. We actually thought it was a fairly modest provision that simply directs the State Board to do the public trust analysis that has not yet been done over the last 30 years. And I think that everybody does agree is the first thing that really does need to happen if we are going to get serious about protecting our ecosystem. So we simply are looking for some of that process language to get cleaned up. And then, and I think there's then at the end of the bill, well, I think there's just some smaller technical things, but that was the primary issue on my mind.
Assemblymember Ruskin has a question. Before we go there, I want to just give everybody a big heads up that we're going to need to start the next panel at 10:45 sharp. And that means even if someone is mid-sentence, unfortunately, because of the limited time we have and the fact that we disappear into session at noon, we really do need to start that at 10:45. So with that, Assemblymember Ruskin, and then we'll go to other members.
Senator, good morning.
Assembly member.
I have a question. You were talking earlier about the various water agencies hoping that they'll get on board. And I have a question from one of them. This is concerns brought to me by BOSCA. I just want to address one of them here. And perhaps you can address their concern. This particular concern, in talking about the legal protections of already existing rights, BOSCA is concerned, for example, that the first in time, first in right is not expressly or adequately addressed in the current bill. They're concerned, for example, that some of the rights, some of the water sent to Central and Southern California, principally responsible for damage to the fisheries, have rights that are newer, much newer than and therefore junior to San Francisco's. They're concerned that the first in time, first in right principle is not adequately or specifically addressed. Do you give me some general comment back on that?
No, Mr. Chairman is more of an expert in this than I am, so maybe we can tag team it. But the bottom line is that this particular issue is another example of agencies, and I understand it, it's not criticism, just more of an observation, trying to improve upon their existing water rights as opposed to ensuring that their current water rights are not harmed. And that's sort of the fundamental demarcation here. We can't use the bill here to rewrite water law because this is hard enough. Frankly, without trying to engage in that endeavor. And adding the doctrine of first in time is a fundamental rewrite of California water policy.
And just to elaborate on that a little bit, obviously we have a century plus of developed water law in the state of California. The idea of prior appropriation, first in time, is one of many, many principles in that 100-year body of jurisprudence. But there's ambiguity and unsettled elements of that. And it's not as simple as just who gets the water first. There's the public trust doctrine. There's reasonable and beneficial use. There's some ambiguity about whether someday, if folks are asked to contribute water to meet the public trust obligations in the Delta, whether it would simply be a seniority-based analysis of who contributes, which is what some would argue from that body of law, or whether it's a more equitable distribution that considers other factors. The law is unsettled. And the approach that we've taken here is not to answer questions that are unsettled, but rather to simply say we're not changing the law as it stands right now. And so San Francisco and others obviously will be able to assert their strong seniority, their pre-1914 rights, and other things that give them one of the best protected water supplies in the state. But we're not going to resolve ambiguities in this 100-year body of jurisprudence in favor or against any of the parties that may choose to argue otherwise if that dispute arises in the future.
And one quick follow-up. I know your time, this will just take a second. So I have to Mr. Gilbert. So I imagine, I gather SFPUC is content with that interpretation.
Thank you. Assemblymember Ruskin, we had similar concerns. I don't know if they were identical, but they were certainly similar as we went through this process. And I think that we feel, given our concern, we wanted to balance those concerns with our concern about the Delta. And I think that we feel that the protections, the language that we were able to achieve through these discussions sufficiently gives us peace of mind that we can continue to assert our water right and also help the Delta get better.
Thank you.
All right, other questions? I think Assemblymember Yamada was next, and then Ms. Fuller, and then we'll go to Mr. Randall.
Thank you very much, Mr. Chairman, Senator Steinberg, and everyone. Thank you for all your hard work. As I said to you on Friday, September 11th, in the late hours, I do not doubt your sincerity and the efforts that all have been made to get us to this point now. But I continue to have concerns about the governance issue in particular. And I wanted to ask you this question, having read the bill over the weekend, and actually it was a nice birthday present that was filed on Friday, October 23rd.
Happy birthday.
Thank you. Goldenrod is one of my favorite colors. Although I just saw this morning, I wanted to ask you if you could explain for me and perhaps others how you see the organizational relationships amongst the what I call the 3 C's, the Council, the Commission, and the Conservancy. I did try to extrapolate or interpolate, whichever direction you wanted to go, by reading the bill. How, and I see you're calling one of your very expert and
just
one of our
find the
constituents,
page,
yes.
that's
Because the bill speaks to, all of the different governance groups that will remain active participants and advocates for the Delta. And it was really not clear to me how all these groups would be interrelated. That is outside my continuing concerns about the makeup of this body, who will appoint, who has confirmation authority. I think we all know that the Senate and the Assembly are a little bit different. And, of course, the Senate, I'm not arguing that, that is the authority of the Senate to do confirmation. But I just have these concerns about this governor in particular, about the fact that, the Assembly hasn't even appointed an Assembly representative to the Delta Protection Commission all year. And so I see that we need to, at least from my perspective, speak up about the involvement of Delta legislators. In fact, I have some screens or whatever they call them, little handouts. They're not handouts, but I have information there that actually shows who represents the Delta currently. And I just have continuing concerns that those Delta legislators are still not really involved in the discussion. So with that, that's just my preface remarks, and we'll wait to hear.
Let me see if I can answer a couple of questions quickly. On the issue of appointments to the Delta Stewardship Council, and with regard to this governor, Governor Schwarzenegger, who has been very, full negotiating partner, been working in good faith with the legislative leaders to try to get this done. He would have a governor would have 4 appointments, and we provide for staggered appointments, 2 for 4 years, 2 for 6 years, which means that the next governor, if he or she were to win re-election, would have the authority to appoint. What's that? They would still be in their first term. That's correct. If the appointments are made next January, February, it would be the next governor's last year of his or her first term that governor would be able to appoint 2 members anew, and then the next governor or the re-elected governor would be able to do so in the first year of that second term. So we did stagger the terms, in addition to the Senate and Assembly having appointments themselves, and of course the Delta Protection Commission. So I think the concern about, you said you're concerned about this governor, the appointments are spread out in such a way that I think it gives this governor, I think, the rightful ability to get us started here with Senate confirmation, but then we'll allow subsequent governor to also have input. Secondly, on the relationships between the various entities. Thank you, just in time here. The Delta Protection Commission, which is, of course, an existing entity, existing body in law, has some special authority when it comes to the relationship with the Delta Stewardship Council. Not overriding authority, as Senator Wilk said, not veto power, but on page 20 of the bill, that the Commission's authority is stated as follows. A proposed action appealed pursuant to this section shall not be effective until the Commission has adopted written findings based on substantial evidence in the record that the action, and this is the Delta Protection Commission's action, that the action is consistent with the Resources Management Plan. Nope, I'm reading the wrong thing here.
Right, I want the other one,
Where
I
is
think,
it?
although I was a bit confused.
Okay, here it is. Sorry. Page 21, line 6. The Council, the Delta Stewardship Council, shall take into consideration the recommendations of the Commission, including the recommendations including the Economic Sustainability Plan. If the Council, in its discretion, determines that a recommendation of the Commission is feasible and consistent with the objectives of the Delta Plan and the purposes of this division, the Council shall adopt the recommendation. No other entity that I know of has that kind of a specific statutory set-aside in terms of how the Stewardship Council should consider their recommendations.
Well, if I may just continue, you know, I think that is the portion that I find most troubling, is that the phrase "in its discretion." You know, we have here an appointed and not elected body that is going to essentially guide and provide. I mean, it's Stewardship Council, and again, those are. I just want to reiterate. Those are some of my concerns about the governance piece, which I think, and I'll just conclude here, because as you say, we're going to have other opportunities, maybe this week, but that, you know, again, the governance piece is so important in terms of establishing trust, and you know, we're trying to perhaps depoliticize this process on one level, but you have a political coalition, as you described it here with you sitting now
I
for
didn't
this
describe
panel.
it as a political it's
I thought you did, but
well, political and substantive, right? They go together.
But again, we appreciate all your efforts, and we'll continue to try to come to a yes at some point. But I'm not there yet, as you know.
Thank you, Assemblymember Fuller.
I have two questions, and I thank you for your work, and that we're still trying to get water. That's important to all of us. Thank you. The first one is, I understand that there are 7 appointments to the council, and of those 7, if we only have 4 appointed, how many people does it take to pass a motion?
4.
4. Okay, so if it's 4, then is that clarified somewhere in here, that in the bill, that we can?
It's not clear in the bill, but absent some supermajority provision, the standard procedure is majority rules.
Okay.
Not in the legislature always, of course. That's another story.
Well, let's just say we've learned not to trust anything we can't read. And then the second thing is, under what conditions could the primary Delta zone be expanded by the council?
I don't know the answer. Under what
conditions could the primary Delta zone be expanded by the council? And having to do with that is the land use authority within the Delta. So I'm trying to get to.
I don't think there's any authority to expand the primary zone. Again, when it comes to the...
It's studied, right? It's in recommendations.
It's a study. It could only be changed by statute. And, of course, with the secondary zone, where most of the conversation has occurred, the compromise we have crafted would exempt those lands in the secondary zone, that are consistent with the blueprint called for under Senate Bill 375, enacted in 2008 and signed by the governor in 2008. So the bottom line is we looked at it geographically. We looked at trying to have some sort of a dividing line. That didn't quite make it in terms of trying to bring consensus. And so in working with the Sacramento Area Council of Governments and in working with the environmental community, the 375 framework made some sense, because we want to encourage those developments under a different body of law, and that seemed like a fair way to go about making a subjective division here.
Thank you.
Did you want to add to that, Senator Steinberg?
Well, I just found on page 101 of the bill, the council is, in fact, lines 18 and 19, governed by a majority of the members of the council at a meeting duly called and held. So it is majority.
Very good. Assemblymember Rambula.
Thank you, Mr. Chairman. Mr. Pro Tem, thank you for all of your work on this critical issue to our state. And the very fact that you have managed to keep the coalition that you have at the table as you've worked through all of these iterations is a real testament to your perseverance and your ability to negotiate. I think perhaps the definition of a good agreement is one where all of the parties say, if they, whoever they is, if they get one more amendment, I'm walking away. And I'm sure you've probably heard that, or from all sides, I suspect. And
only daily.
I would like to comment on some of the protections for the Delta that I think are new or enhanced from the previous versions. And the language in Section 3 of 6103.1, the first section of the bill, says, it reiterates the co-equal goals, but it also says that a goal is to protect and to restore and to enhance the Delta. That the co-equal goals shall be achieved, shall be in mandatory, shall be achieved in a manner that protects and enhances the unique cultural, recreational, and natural resource and agricultural values of the Delta. That seems to say that the co-equal goals can only happen when or if and when the Delta values are protected and enhanced. I'm wondering if you could clarify that.
It's interesting because there are a lot of water lawyers, and some have interpreted that section in just the way you described, that the co-equal goals, and I don't agree with this, by the way, so I should be wary about even saying it, but that the co-equal goals are actually subordinate to the modifier that you just read, that it all has to be done in a manner that is consistent with the vernacular Delta as place, to paraphrase. And because the two co-equal goals have to be balanced, but both only have meaning if they are consistent with what you just read. And so there was a lot of argument about tri-equal goals, co-equal goals as modified. This language seemed to be the best, and in an ironic way, not even in an intended way. Some say it might even provide more protection to the Delta than if you balanced the Delta as placed with the other two equal goals. Now, I'm sure that the Delta legislators might disagree with that. It's subject to interpretation. But the bottom line here is that It all has to be done statutorily in a way that respects the Delta as an evolving place.
I also wanted to commend you on the creation of the economic sustainability plan for the Delta. I think that is a critical piece, how to sustain agriculture and the legacy communities in the Delta. In fact, I wish we had that same requirement for some of the communities in my region of California, particularly on the west side. But I won't go into all the details, Senator. I think there are adequate protections for the Delta, enhanced protections for the Delta, and I hope we are at the point where we move ahead with this package. It's tenuous, I understand, but I suspect that if there are significant additional requests from any party at this late stage of the negotiations, that it runs the risk of derailing the entire effort. I hope that when this matter, if and when this matter comes to us for a vote in both of our houses, that we will put aside our parochial interests and look out for the well-being of the state, which I think this package represents. Otherwise, we run the risk of balkanizing California, which I know is not your intent and certainly not mine.
All right. Well, thank you. And with that, the hour of 10:45 having arrived, it's time to thank Senator Steinberg and this panel.
Thank you, Mr. Chair and members, for
thank you for your great work. And we are going to welcome up the next panel, which is a little bit different than anything we've heard in our prior hearings on this issue, on these bills. This is a panel of experts, and when we talk about a comprehensive solution to California's water problems, that means many things to many folks. We're going to be looking at financing and other issues in our next hearing, but some of the very important elements of comprehensive, in my view, are represented in the land use, water rights enforcement tools, groundwater monitoring, and water conservation elements of this package. And so we are fortunate to have with us some great authorities to speak to those elements of the package. We're going to welcome Patrick Johnston, obviously a former senator from the Delta, author of the original Delta Protection Act, and advisor to the bipartisan working group and authors of this legislation. We also have with us Professor Rick Frank from UC Berkeley with 30 years of experience as an attorney for the state, Chief Deputy Attorney General. He is the Executive Director of the UC Berkeley Water Center and also was the co-chair of the Delta Vision Blue Ribbon Task Force. Catherine Freeman from the LAO is joining us. She's an expert on water and the primary author of the LAO's report on groundwater, so she will be able to speak to that. And finally, Dr. Juliet, Christian Smith, Juliet, who is a water resources expert at the Pacific Institute and an author of recent agricultural conservation reports. So welcome to these witnesses. Thanks for joining us.
Thank you, Mr. Chair, Madam Chair, committee members. The issue of governance is essentially a political question. The Delta is an estuary that's determined by nature and measured by science, but governance structures are political, and they're made by men and women. And those governance structures start with the boundaries of the state of California and the boundaries of counties, and later the growth and boundaries and changing boundaries of cities. And also, it's true, governance structures affecting the Delta and the water system. As noted, the many different jurisdictions with some authority over the Delta have created enough confusion, conflict, and inaction to merit your attention and the attention of many of us who came before and didn't do the job. You have a hard job, and we're here to help, but it is a big burden on you. I think if you look at the Bay Delta Authority, which I've served on since its creation, it was ineffective, did not prove to be a good structure to manage our water system for many reasons. One key one being that the federal government would not, perhaps could not, participate on a co-equal basis. And so in governance, you're moving ahead with, as Assemblymember Yamada said, the 3 C's. And so the Delta Stewardship Council with 7 members is a reasonable way to provide oversight better than what we have. And investing it with sufficient authority, guided by the 2 principles in law so that they carry out the law, and that being a reliable water supply as well as an improved Delta environment, is good. Having one of those members, but only one, represent the Delta and the Delta Protection Commission makes sense as well, so that always that voice will be there. But really, you want a statewide perspective. You want terms and some insulation from the understandable parochialism that we all feel on water. We think about water based on where we live. We want a council that, to the degree possible, elevates considerations to the statewide interest. One member from the Delta, because it is so uniquely affected, is a good contribution. The Delta Protection Commission is the 2nd C. What problem was it created to solve, and what should happen now? Well, the history of the Delta over the nearly 100 years from the late 1800s into the 1970s was restoration of marshlands, creation of islands, primarily farming in those areas. And then, as California grew and the Bay Area grew and the Central Valley grew, urbanization pressed in. And so in a decade from 1980 to 1990, 10% of the Delta was urbanized, the same amount that was urbanized over the previous 90 years. So urbanization was accelerating. In 1992, then, the legislature passed, Governor Wilson signed into law, the Delta Protection Act. And fundamentally, that was a political governance document. So it can be changed, but we ought to understand what it does and why it exists in the form that it does. If you look at the Delta, which again is an estuary that scientists ought to define what happens there as water moves in and out and mostly below sea level, and then you come along in the 1990s and say there is a need to better protect this area if we want to assure for the present and the future agriculture, wildlife habitat, recreation possibilities, and a better mixing zone for our environment. If we're going to do that, and also then be able to make other decisions, but have that land not all compromised by a lot of decisions made by cities and counties that seeking their own manifest destiny to grow would do things that worked for them. The analogy is to San Francisco Bay. Before the 1960s, all the cities were growing in into the bay. A third of the bay is covered. San Francisco is. Foster City came out of nothing. Berkeley, Oakland, all of them, Alameda, they all filled in the bay. And so the legislature, in its wisdom at that time, passed the Bay Conservation Development Commission, which set a regional body that had both local government representatives and state representatives, and said that you need special permission in order to encroach on what remains of the bay. And it is kind of that model that the Delta Protection Act was created. But the political reality in 1992 was cities and counties, Contra Costa, Solano, Yolo, Sacramento, San Joaquin, had all, and their cities, had all said, we're building out to here. They argued that they had promised their communities, those landowners, those who wanted to develop, that they were going to move out to a different point in time. Sometimes those made a lot of sense and were on the books for a long time. Sometimes they didn't. So in the little burg of Lathrop that was created just before then, 5,000 acres on Stewart Track below sea level in the South Delta, recently flooded, and then when it was patched up, Lathrop decided and got permission from San Joaquin County LAFCO to create an urban area that will supposedly have 11,000 homes someday. So, what did we do? We made a political compromise and said, we are deferring to the judgment of the big cities like Stockton and West Sacramento in the Delta, and the little tiny ones, even Isleton and Lathrop, and said, you have land use jurisdiction, and the state is not going to restrict you from making decisions there. Yet you're, in some cases, in the Delta, and ought to pay attention to that. And then the law said that what remained, the core of that, would be called the primary zone. But it's a political boundary, and it's what's left after all the cities and counties spoke for what was in their mind's eye to develop in the future. So if you fast forward from 92 to 2009, we find that a lot of that has been built in. And so in the legislation you were looking at now, it is a good model, and the legislation is correct, to continue to vest the decisions and the planning process to fulfill the goals of agriculture, wildlife habitat, and recreation in the Delta with a commission that in this legislation changes to be 11 out of 15 members local and 4 state representatives. And so that's a strengthening of local control on what happens on the ground. This is not primarily about water. This is about what happens on the islands. It is important in the legislation that what that resource management plan and that commission does is consistent with the state Delta plan, because the state's interest is very large in the Delta, and so the commission and its work should be consistent with what the state does. A couple of things in the legislation that have received a fair amount of attention. One is the economic sustainability strategy. Well, this is a political discussion. It's necessary to talk about. But when you think about the Delta and you think about the 5 counties and the supervisors who represent those 5 counties, think where we are today. We're in Sacramento County. There's over 1 million people here, and there's lots of economic activity, and there's a lot of homes, and there's a lot of businesses. Hardly any of them are in the primary zone of the Delta, and only to a limited extent are they in the Delta itself. The city of Sacramento, Folsom, Elk Grove, Carmichael, all of these places are part of the economy of this region, and whether you did everything or nothing in the Delta area, it would have little effect on the overall economy. And so too with Contra Costa. If you drive through the 680 corridor and see all those cities and big economies operating there, what happens out in the Delta is of small economic significance, and the other counties similarly. Economic activity, however, is important to the property owners in those areas, and historically that's been agriculture. So as was cited about the San Joaquin Valley, if you could figure out strategies to help agriculture, that would be a good thing. So it's worth paying some attention to, but don't get carried away with that. And I really don't think that an economic strategy plan ought to have the force that whatever it decides shall be implemented unless the council finds some grounds to override it. So if you think about this, you have the council making policy, You have a commission that is strongly local control, figuring out what happens on the ground and recommending and having an important seat, the chair, at every meeting of the council. And yes, doing a resource management plan, think of it as a general plan that a planning commission does, and does an economic strategic plan, which is fine. But the economic activity that makes money is building houses. The law already says that agriculture is the primary purpose. So let's not kid ourselves, not that you are, but when you talk about economic activity and you're a property owner, what's going to make you money? Building houses. And if you go down and you drive around the Delta, the places that aren't 20 feet below sea level but are in really nice areas that have permanent crops and everything, people are buying 20 acres or 40 acres. It's their yard, and they're building a big house. That's the economic activity. So, does this matter to the state and people from different areas and people concerned about water policy? I would suggest that retaining as much of the undeveloped delta in its natural state is good for whatever decisions you and the council and the state in the future make about water transfer or for environmental enhancement. Lastly, I wanted to mention that as you go down the road and make a decision, then it gets interpreted by others. So it was a political thing. 1992, we said, well, how much can we protect of the Delta? And we concluded we could protect everything that cities and counties said they weren't interested in. Okay, so that was protected. You fast forward 10 years, and the city that I live in, Stockton, the mayor shows up at the Delta Protection Commission, and he asserts that the legislature instructed local government to build out right up to the boundary of the primary zone. Everything in the secondary zone is possible. That's how he interpreted the Delta Protection Act. So, in fact, the authority is limited on land use in the primary zone, but it has been silent on what happens in the balance of the Delta. And as a consequence, the Delta Protection Commission, over a long period of years with its staff, has commented on some proposals in sensitive areas, and they're enumerated in the Blue Ribbon Task Force report, sensitive areas in Contra Costa and in San Joaquin and the other counties that ought to be protected, but they're not in the primary zone, and the Delta Protection Commission would comment on them. I'd say don't go backwards. Don't fall over yourselves to try and please what is a local interest, understandable, but nevertheless limited a view that would suggest that the Delta Protection Commission has no ability to even examine and comment what happens in that secondary zone. It's a delta. It's an estuary. Nature determines it. Political people apply the best judgment we can on governance.
Thank you, Senator, for that overview on the governance and land use piece. We're going to hold questions till the panel is finished, and we'll go next to Professor Rick Frank. Welcome.
Members of the committee, I'm here testifying not only in my academic position with the UC Berkeley School of Law, but also, as was mentioned by the chairman, as a former member of the Governor's Delta Vision Task Force and current member of the Delta Vision Foundation. I've been asked to speak specifically on the issues of the water conservation, groundwater monitoring, and water rights enforcement provisions of the bill that is before you. Although time permitting, I would like to make a couple of brief comments about the Delta governance provisions of the bill as well. Before doing any of that, however, I just would want to endorse and echo the testimony of former Senator Johnson. I had the privilege of helping the senator and his staff to implement the Delta Protection Act in 1992 and served as the Delta Protection Commission's first attorney for the first 7 or 8 years of its existence. But turning to the issues of, first of all, water conservation, the Delta Vision statement and strategic plan emphasize the fact that statewide water conservation is a critical component of any viable and effective strategy. to restore and protect the Delta. As one of the earlier witnesses said, it's really a cornerstone of our collective effort. Those efforts that are contemplated in the bill are both feasible and necessary, and I would parenthetically note that the rest of the state can, I think, learn some lessons from some of the cutting-edge water conservation reforms enacted south of the Tehachapi's by local governments and local water districts there, which are leading the state. The water conservation goals contained in Senator Steinberg's bill are achievable, modest goals. They're certainly consistent with what the governor has already directed in terms of the per capita reduction in urban water use, 10% by 2015, 10% by 2015, 20% by 2020. In the past, in the recent past, the state of California has been a leader in reducing per capita energy consumption through the Warren-Alquist Act and related statutes and regulatory reforms. Through the leadership of especially Senator Pavley and others, the state is a leader in reducing aggregate and per capita reduction of greenhouse gas emissions. There's no reason that the state can't exercise a similar leadership role with respect to water conservation efforts. The water conservation standards specified in the bill are performance standards. Local water suppliers are given broad discretion in how to obtain those per capita reductions. The Department of Water Resources has an important but limited role in setting those standards and enforcing them. Could they be better, in my view? Yes, they could. Only carrots are provided to induce compliance with these water conservation standards in the form of withholding or offering state water grants and loans. No sticks are involved, and in my experience, a combination of carrots and sticks is often the best enforcement strategy. The other concern I have about water conservation standards contained in the bill is that California agricultural users are not subject to the quantified conservation goals that urban water users are under the legislation. The agricultural standards are more vague and aspirational in nature, and in my view, more quantified standards are warranted in the agricultural sector just as they are in the urban sector. Turning to groundwater monitoring. This is, in my view, a modest but very necessary step to address what I believe the bill characterizes as critical conditions of groundwater overdraft throughout the state of California. California, as I believe has been mentioned, is the only state in the western United States without a system of groundwater monitoring and regulation. It's an anomalous situation relative to our western state neighbors. As a result, in the state, particularly in recent years with the 3-year drought that we're still in the middle of, as surface water resources have declined, water users have relied increasingly on groundwater extractions, in many cases with adverse environmental effects. In coastal areas, we're seeing saltwater intrusion and groundwater basin contamination of freshwater groundwater basins in the Central Valley as a result of enhanced and increased groundwater and unregulated, unmonitored groundwater pumping, substantial subsidence, surface subsidence extending to 55 vertical feet. Under the terms of the proposed legislation, it is local entities that are responsible for the groundwater monitoring efforts that are mandated under the bill. It is up to state officials at the Department of Water Resources and others to see that that information is assembled and made readily and widely available to policymakers and academics and others, and I think that's a very good thing. Again, could these provisions, in my view, be improved? Certainly. I would have the same characterization that what we see in terms of insurance or leveraging, encouraging compliance with these groundwater monitoring and reporting requirements consists of some financial incentives, carrots, carrots, no sticks. And I would also note, in terms of my own views, and I've stated these previously, there are no limits on currently in this legislation on the aggregate or individual amount of groundwater pumping. In an ideal world, I would be advocating for that, but I think it's important, given all that you've heard over today and over the last several months, to not let the perfect be the enemy of the good. Turning to water rights enforcement, during the Delta Vision Task Force's hearings, it became quite obvious in testimony before us from a variety of stakeholders and from the Water Board staff and chairperson herself that the Water Board lacks the funding, the the staffing and many of the legal tools to enforce California's existing system of water rights laws. So you have an uneven playing field where some people are simply illegally diverting water, using it, not reporting what their surface water diversions as is required under law. So you've got this anomalous situation of a number of water users, most water users, trying to comply with the existing laws, but a substantial minority of folks refusing to do so. And with that lack of personnel and fiscal resources and legal tools, that has resulted, in my view, in an under-enforced system of existing water rights. We've had an antiquated system of fines and penalties that, as your staff has reported, has not been updated in many, many years. And I think this bill contains a number of modest, incremental, but important reforms. First among them, I think, is giving more money and more staffing resources to the Water Board, 25 additional positions specifically focused on enforcing California's existing system of water rights law. For the first time, imposing fines on those who ignore existing, and if this legislation is passed, prospective authority to report surface water diversions and groundwater diversions. Currently, there's a long-standing mandate to report, but there have been absolutely no sanctions for those who refuse or are unwilling to do so. And the State Water Board reports that approximately a third of statewide permit holders are not reporting current surface water diversions. That's simply unacceptable, and the board has, up till now, not had any enforcement tools to address that problem. The bill also allows, for the first time, would allow the State Water Board to convene a stream adjudication without a petition being filed by a member of the public. That's important. The board's ability to act administratively without going to court is enhanced somewhat, not as much as I think it should be. I'll talk more about that in a moment. There's very good legislative intent language about the legislature's intent that there be a level playing field and there be an adequate and fair and comprehensive enforcement of California's existing water rights system. There's an increase in the fines and penalties and really an elimination, I would characterize it, of the incentive to ignore or violate the existing water laws. That's hugely important, to remove that economic incentive to disobey the law. My concern here with this bill is with respect to something that was mentioned, I believe, by Senator Pavley, and that is that there are no provisions for interim relief, administrative relief, to be adopted by the State Water Board while it's undertaking its investigation and convening its hearings. The problem, and I think recent political and regulatory history demonstrate this is an incentive for parties and indeed, in some cases, the board to delay taking action that needs to be taken. In my view, interim relief should be a part of this legislation, subject to due process guarantees that those who feel that that's excessive and inappropriate have a judicial remedy, but the board, in the first instance, should be allowed to both adopt those interim remedies, including cease and desist orders. With respect to the water provisions, I would also just note in reviewing the language of the bill this weekend, I found a couple of what I would characterize as technical errors and omissions, and rather than spend the members' time now, I would just offer to work with staff to point those out. Very briefly, turning to the governance issues, as a member of the Foundation, I know I speak for my fellow former task force and current Foundation members. We're very pleased to see the overarching co-equal goals identified by the task force as playing a prominent cornerstone role in the governance provisions, and that all 7 of the key goals identified in the task force's 2008 strategic plan are replicated and memorialized in the plan, as well as the recognition that the reasonable use and public trust doctrines are a cornerstone of our water rights system, have been for many, many years, and will and should continue to be so. I do want to finally, though, mention from my perspective moving to the Delta Stewardship Council and this critical consistency process that this legislation would set up. I see, and on behalf of the Foundation, I want to bring to your attention 2 key deficiencies or flaws. First of all, exempt from that certification process are so-called state regulatory actions. State regulatory actions of other state agencies are specifically exempted from the Council's review and certification process under this legislation. I think that's a glaring loophole and one that should be fixed. I'm not in this context referring to the Bay Delta Conservation Planning process, which is really addressed with that process-specific language, but rather the wealth of other state regulatory regulatory actions. And this is, I think, inconsistent with the recommendations of the Delta Vision Task Force's strategic plan and vision statement, and I would hope that it could be readdressed. Even more critically important, as I read the current language of the certification process, if the Delta Stewardship Council, after due deliberation hearing, concludes that a state or local governmental action is inconsistent with the adopted Delta plan, it's my interpretation of the current language that that state or local government still has the ability to readopt and go forward with that process, notwithstanding, and in my view in contravention of the Stewardship Council's finding of inconsistency. That's the language found at page 102 and 103 of the bill. That seems to me a serious problem. The Delta Protection Act, which Senator Johnson talked about, gave greater consistency review to the Delta Protection Commission over local government land use decisions that came before it, for consistency review. And I would also point out that under existing federal law, the San Francisco Bay Conservation and Development Commission and the California Coastal Commission have far greater and more effective consistency review over federal activities in the coastal and bay zone under existing federal law than would be provided under this version of consistency review contained in the bill. And I think that's a major weakness and shortcoming. It is not consistent, in my view, with the recommendations of the Delta Vision Task Force, and I would hope it could be revisited. I think with that, time is short. I will conclude my testimony. I will, of course, be happy to answer any questions that the members may have.
Yeah. Thank you, Professor. We'll go to Catherine Freeman from the LAO. Welcome.
Thank you. My name is Catherine Freeman. I'm with the Legislative Analyst's Office. Thank you, Madam Chair, Mr. Chair, for letting us come here and speak to you. I think most of you have heard us speak a little bit on water financing. Today we're going to turn from water financing to groundwater, and we'd be also happy to answer questions on water financing as that hearing comes up later. We took a look at groundwater a couple of years back when the couple of assembly hearings came up on drinking water quality. And we took a look at what groundwater meant to California's water system. And we're certainly not the first and we're not the last that are going to do this, but we had some concerns about the future of groundwater in California and took a look at Department of Water Resources projections for water supply and how groundwater fits into that mix. And so I'm going to go through a little bit of how we came up with some recommendations and then take a look at the bills and see how they progress. Overarching, though, I would say that the bills are a step in the right direction. Groundwater is important to the state, and it's been made so both in statute and by the Department of Water Resources. It's part of our water supply, and sometimes it's a question of, why is it treated differently than surface water? It's the same thing when you pull it out of the ground and we drink it, or we put it on our crops, or we use it in our homes or our landscaping. It truly is water. So the question is, why do we treat it quite differently than surface water? We looked at the future of water supply, and Department of Water Resources has made no bones about it. There are concerns about the future of water supply reliability in many areas. The interesting thing about groundwater is that it supplies, in some years, 20% of water supply to the state, in some years, nearly 40% of water supply. So in a dry year, as we've had in the last couple of years, it's supplying quite a bit of our water supply. But the question then becomes, where in the state is it the most important? In some areas of the state, groundwater supplies 100% of a community's drinking water. It's 100%. If a groundwater supply becomes polluted or contaminated, that water supply is no longer there, and it's up to the community to try and figure out, well, how are they going to get water to homes that are existing, pipes that are existing. They may not have surface water rights. They may not have other ways to get water supply, and that becomes a concern. The same is true for agriculture. When the water supply becomes, if it's polluted or is overused, it no longer becomes a reliable supply of water for those farms and for their communities. And that is of great concern as we move forward in an era where we may not have quite as much water as we used to have. One of the things that we emphasize is that we don't have a water rights system for groundwater. It is up to the locals, and California, as has been mentioned, is pretty much the only state in the western United States that does not have some sort of either comprehensive water monitoring system or groundwater rights system. Texas does not have a water rights system, although it's in the courts, but they do actually have a very comprehensive water monitoring system and an extraction monitoring system where all wells are reported to the state. The state then reports that information on a publicly available database. So the state that didn't really have water rights and that we were compared to has a much more comprehensive monitoring system than we do. I would say that there's a great body of law for groundwater, and it's difficult to go in and change that body of law. Mainly, the law gives locals the most control over groundwater, which can be a very good thing because locals are the ones that are impacted the most. We do have those 10 state agencies that have groundwater programs, and they range from water supply, water quality, science and monitoring, cleanup, and local financial assistance. That's a good group of folks. The federal government doesn't have quite as great a role in California for groundwater. They do in surface water, they don't in groundwater. They do, however, provide a good deal of technical assistance to the state. They initiate studies, and they also perform studies on our behalf, both for water quality and for water supply. And so they've been a partner in some ways. Funding for groundwater is all over the map. Our baseline funding for groundwater has been in the $10 to $50 million range, mostly for water quality cleanup. But when bond funds come in, I'll give you the graphic by hand, but it sort of goes up, down, and then really high up and then down. And so I only say this because it's not really consistent how we pay for groundwater. And that can be of concern both to the state as we decide whether we're going to report groundwater to folks, but also to locals, because they're not able to access either a steady stream of funding or to rely on the state if issues come up for groundwater. And so we would say that that's probably of concern. So I said that the bill is a step in the right direction, and in our minds it is. There is a movement forward towards reporting groundwater, whether we report groundwater elevations or groundwater extraction. Those are two separate and different things. We would recommend that as the future unfolds, the state consider how they would like to look at extraction of groundwater, and whether that looks that as a permitting system, whether we permit basins to extract a certain amount of water, whether we require not voluntary but mandatory management of groundwater basins, because it is in the state's best interest to have groundwater basins manage their water effectively. And there are some basins in the state that are doing a phenomenal job at this. They know how much folks are using, they have disagreement, and they have a publicly available process to determine who gets water and how much water is coming out. The actual presence of information shouldn't deter locals or agricultural interests or residential interests from reporting their groundwater use, because as we move forward and water supply becomes more, hopefully more reliable, but there's more challenges as we look at groundwater, I think that it's important that the state provide either some technical assistance or some help to locals as they try to manage their groundwater. And there's some basins that really need some help. So we would, in the future, recommend much more stringent monitoring. But again, this bill is a step in the right direction, and we're happy to answer any questions on this.
All right, thank you, Ms. Freeman. And last, we'll go to Dr. Juliet Christian-Smith on the issue of water use efficiency.
Great, thank you. I'm a senior research associate at the Pacific Institute. You may know that we do a lot of our work on water resource management and have done numerous studies on water conservation and efficiency in California. So, I mean, it's already been said there's consensus around conservation as a cornerstone of this legislation, from the governor to Lester Snow to many urban water agencies and agricultural irrigation districts. Water conservation just makes sense. It's a relatively fast, inexpensive, and ecologically sound way to stretch increasingly scarce water supplies. So today I just want to congratulate you on the progress that's been made towards water reform. And I want to encourage you to adopt the quantitative water conservation targets across the board that are needed to achieve real progress. Today, I learned that the current legislation has kept the quantitative targets for the urban water use, 20% by 2020, and this is an important step forward. Several years ago, we published the first statewide analysis of the potential for water conservation and efficiency in the urban sector of California. And the major conclusions were that 1/3 of California's current urban water use, which is more than, at that point in time, more than 2.3 million acre feet, could be saved with existing technology. And that 85% of that, or more than 2 million acre feet, could be saved at costs less than it would cost to tap new sources. What did we mean by existing technology? Well, at that time, we were talking about low-flow toilets, washing machines, shower heads, dishwashers, and leak reduction. Today, there are even better technologies and efficient solutions available. While we have made some important gains, you might be surprised to know that we're currently crunching some data, and it suggests that only about 30% of California urban users actually have low-flow toilets and some of these other water use efficiency technologies. So why is this number so low? For decades, we've been relying on voluntary programs. And while they are important, they don't create the real incentive for change by the user, by the water district, by the irrigation district, and to fundamentally change and rethink practices. I'll just give you a for instance here. The 2005 baseline that the 20 by 2020 team is using for urban water use is 192 gallons per capita per day in California. That is where we're starting at. Just to give a comparison, the baseline in Queensland, Australia, where they have had quantitative targets in place for several years now, is 43 gallons per capita per day. And this is even after mandatory drought restrictions were lifted. So this is their baseline that's been stable. It's worth noting this because Australia has a similar climate as California. We have a similar standard of living. Obviously, there's room for improvement here, but quantitative targets are critical for setting the bar. Another surprising fact is that 60% of California's agricultural land is still flood irrigated, water flowing across fields through basins or furrows. And this has high evaporative losses and also losses to deep percolation. And this is important because no matter how we measure it, agricultural water use is the big elephant in the room. It's the big major water user in California. And agriculture is obviously critical for our nation's food security. So we've really got to get it right when it comes to agricultural water conservation and efficiency. You may be familiar with some of our recent reports, Sustaining California Agriculture in an Era of Uncertainty and More with Less. These two reports looked at potential agricultural water savings that could be achieved using existing technologies like drip irrigation, sprinklers, irrigation scheduling. And you might also be aware of some of the pushback of those in the agricultural community. And I want to emphasize some because many growers who are dealing with the on-the-ground reality realize that things are going to change and have called and written to us to express their support and are the subjects of a study that we're currently doing on agricultural water use success stories. There are a lot of examples of grower-led innovations on the ground, major strides that are being made. Craig McNamara, who's on the Board of Food and Agriculture and is the owner of Sierra Orchards, says that conservation is a critical part of what we're doing on the farm and as citizens of California. Drip is the way to do it. When you go from furrow to sprinkler, you reduce your water use in half, and when he went from sprinkler to drip, he reduced it in half again. This is the only way. If we're not mindful and good stewards of our water, land, and air, quite frankly, we just won't have it. Karen Ross, who is the president of the California Wine Growers Association, which is it has a very successful sustainable wine growers program that these vintners and wine producers actually benchmark their practices, including water use. She says, obviously water is a precious resource in a state like California. It's interesting to note that precise water management is the fastest and best way to improve wine quality. And when we really understand water, how much to use and at precisely the right time will improve fruit quality and wine quality. And just one other voice from the many people that we hear from, Tom Rogers, an almond grower and a vice president of the Madera County Farm Bureau, says he has a very extensive monitoring system on his property where he's actually monitoring his water use. He says sound irrigation practices are an absolute must if we're going to continue what we're doing. It's absolutely imperative to know where your water is and if you're actually using it or flushing it through the system. We can water according to a calendar, or we can water according to a tree's needs, and we are trying to meet the tree's needs. We've actually reduced water consumption by about 25%, and our yield has gained. So I used to work for agricultural extension. When you go out there and talk to farmers about water management, they're going to tell you what they're already doing. And they're also going to tell you what they'd like to do if they had the right financial support and political incentives. I think it's frankly disingenuous to pretend there's no room for improvement in the agricultural water use area. Studies estimate potential savings ranging from 500,000 acre-feet to about 6 million. And I understand that there's a lot of pressure not to look at quantitative targets, to ignore the people who are doing it on the ground, to ignore the science. And yet, I argue that we will not meaningfully address the full California water crisis unless we set quantitative targets for agricultural water use. Obviously, these targets have to be mindful of different crop types, of different soil types and climate zones. But they're critical to making our agricultural sector not only more efficient, but also more resilient to changing climate and a more uncertain future. So I'd like to thank you, and I'm open to questions as well.
Thank you, Doctor. We're going to take a few moments for questions of the committees, but as you can see, we've got the public already lining up to offer their testimony, and many of them, and not a lot of time, so I think we should try to keep this as brief as possible. Senator Wolk, you had a question.
Yes, I'd just like to ask Professor Frank a question. We heard this morning from Mr. Manning that the package of bills provides a clear path to the peripheral canal, and that's a quote. Others have said, including the pro tem, that the package doesn't do anything to pre-authorize a canal. I continue to be concerned and want to ask you about the oversight of the council with respect to this decision. So my questions, I guess, are two. One, what discretion, in your view, in the current package, does the Stewardship Council have to approve, deny, or modify an isolated facility within the BDCP? And secondly, do you think that the assurances for the Delta, comparable to the one, exist and are sufficient in this package of bills? And what I'm thinking of is the contrast to the kinds of assurances that were written into law and essentially voted down in 1982. But there were very specific assurances to the Delta with respect to environment as well as water, the amount of water that would, and the contracts that needed to be signed. So that's whatever you want, Rick. That's all.
With respect to your first question, I must confess that I've been doing midnight reading along with everybody else, so I am not an authoritative source on this. As I understand from a relatively quick read of this portion of the bill, the council would have review authority to determine consistency of the Bay Delta Conservation Plan with the council's own plan and the enabling legislation that would be enacted. My sense, and again, I want to qualify this somewhat, I'd like to review it more closely, that the council would not, under the current language, be able to pick and choose which provisions of the plan are consistent or inconsistent. It would have an ability to approve or disapprove and send back for further refinement and consistency. That's my best judgment, but it's far from an authoritative one, and I would be the first to acknowledge that. In terms of the assurances, I think this bill, again, I would analogize the bill in respect to the issue that you're concerned about a little bit to the Global Warming Solutions Act, in which the legislature is establishing broad criteria, very ambitious timelines, and giving to a number of executive branch entities, including new one, Stewardship Council, a great deal of discretion, in much the same way the legislature has conferred a great deal of discretion on the Air Resources Board with respect to the AB 32 strategic plan and implementation process. But I am comforted by the fact that the bill in its current language incorporates the co-equal goals and the 7 key objectives of our strategic plan in a way that I think have to provide serve for the executive branch agencies and for the legislative oversight that will undoubtedly continue and should continue over this implementation process to be faithful to those co-equal goals. And I think the one you're talking about is ecosystem protection, restoration, and improvement.
Other questions of the committee? Ms. Yamada, yes.
Thank you, Mr. Chairman. I had a question for Senator Johnston, having been the principal architect of the previous act. How do you feel about I'm going to raise the same issues about the 3 different entities that will continue to have a say over the Delta and how they will be interrelated? I'm talking about the council, the conservancy, and the commission. And I also would like a comment on the water czar or the water master.
Well, Senator Wolk and others have been at this a long time, and so I think this legislation incorporates features of a conservancy that would channel resources in smart ways for environmental benefit and also for economic benefit in the Delta. The commission itself, the Delta Protection Commission, I think fills the role of a regional land use planning body and a central place. If you ask Senator Torlakson when he was a supervisor a long time ago in Contra Costa County, he was on a voluntary body of supervisors who tried to get together to work on Delta issues, and some of them are like sheriff's boating enforcement and things. So it's a good forum to have regionally controlled by regional leaders. And then the statewide council, I think, addresses what brings us all here, which is the sizable effect of the Delta on the state's water system, water resources, and environment. So I think this legislation is on the right track and worth supporting. With respect to the water master, I would defer to others on that.
Mr. Rambula.
Just a very brief comment regarding the opportunity to save water through drip irrigation and other devices. I think it's very appropriate that we look at implementing this statewide. I know in some areas where water has been more scarce or the supply has not been very reliable, that is where we have seen, I think, widespread implementation. And I think other parts of the state that have had either upstream from the Delta or other areas that have perhaps more senior water rights have been a little slower because they haven't had to. But just to share a comment that I heard from one of the farmers that has gone to drip irrigation, he said, I would put in more drip if I had more water to put through those lines. So that comes back to the issue of water reliability as well as some incentives or targets to insist that other people move in that same direction.
All right. Well, thank you, Mr. Rambula. If any of the panelists want to comment or respond to that, you're welcome to. Not seeing any such response, I think it's time to thank this outstanding panel of authorities and experts. We appreciate your testimony, and we are now going to move to public comment. I just want to say as we do so, though, that what I appreciate very much from the testimony we've heard from this panel and the prior witnesses is that this is not a perfect piece of legislation from the eyes of any particular interest, and I can say that myself. I am not pleased, for example, that the Delta Stewardship Council is not as strong as Delta Vision wanted it to be or that I wanted it to be. I'm not pleased that the conservation piece doesn't include quantitative targets for agriculture. I'm not pleased that the groundwater monitoring piece is a baby step at best towards good groundwater policy. I'm not pleased that the water rights enforcement piece is a minor step towards seriously enforcing water theft and overallocation, which is a serious problem in our system. But I compare what has evolved here against the status quo, not against the ideal that I might like to see. So count me in the Arambula camp of defining a good compromise, I suppose. I appreciate the work that's been done and the testimony that we've heard. And we're going to go to the public. Jonathan Clay from San Diego County Water Authority has been first in line, first in time, first in right under California water law, as we know. But I'm actually going to vary from that sacred principle, because the Delta counties have done a great thing for us, something we can encourage other stakeholders to do. There are a bunch of Delta supervisors here, and they've decided that instead of each speaking for their 2 minutes, and we're going to have to hold everyone to that 2-minute time, they would all come forward together and choose one among them to speak. And because they're providing such efficiency, we're going to give them 5 minutes. So take note, other related interests out there. If you come together and choose a single speaker, you'll get a little extra time and you'll get that reward. Thank you.
Thank you, Mr. Chairman. Mary Nedjidley PFO, member of the Contra Costa County Board of Supervisors. I hope to not take advantage of your full 5-minute time limit, maybe be even better relationship with all of you in the important decision before you in the process that we are all in. I am joined by 5 Delta County colleagues, Supervisor Mike Reagan from Solano County, Supervisor Mike McGowan from Yolo County had to leave earlier, but Supervisor Jim Provenza is here, Supervisor Larry Rustaller from San Joaquin County, and Don Natoli from Sacramento County could not join us. He had a prior commitment. We thank you all for your time today and your indulgence in time. We particularly thank Senator Steinberg and his staff who've met with us repeatedly to address our interests. We, too, have met in good faith. We'd like to thank Chairs Huffman and Pavley for our voice with you this morning. We are at a critical crossroads today in a process of good intentions and a desire to build good, strong water policy. However, those of us who live, work, play, and are raising our families on the Delta are facing significant risk from a failed outcome. We are ultimately at ground zero. This is an unfair burden on the Delta and the 5 Delta counties. We must all be taking the risks so that we can all enjoy in the rewards. Currently, that's not the case. Any legislation that addresses water or Delta policy must be linked to adequate, reliable, ongoing funding. Otherwise, the proposed policies cannot be carried out, the Delta cannot be restored or protected, and the state's water supply cannot be guaranteed. Parity is critical. Without reliable funding to address mitigation and restoration of infrastructure and local economies, Delta communities will be devastated by the replumbing of the Delta to ensure additional exports. Delta representation on any new statewide bodies with decision-making authority over the Delta's future is fundamental to the state's achievement of its co-equal goals. We can and will continue to contribute to solutions on the future of the Delta and the state's water needs. The mandate that Senator Steinberg mentioned earlier of the counties having the responsibility, yet no funding or authority for groundwater monitoring raises huge red flags for us. We are working with the California State Association of Counties as I speak, and I'm sure that you will be hearing more from us on that very critical element. When we talk about the need to better address land use policies in and around the Delta, we have been good stewards of the Delta through the Delta Protection Commission and the Delta Protection Act. We are not in the 1980s or 1990s when it comes to land use decisions. Contra Costa County in and of itself has an urban limit line that directs and dictates where urban growth is going to occur, how it will occur, and under what timeline. The Delta Counties Coalition believes in the state's co-equal goals and that they can and should be carried out in a way that protects the Delta as both a place and as a resource. We all are stewards of the Delta, and we all have a stake in its future. We have requested specific assurances to do no harm to the Delta, and we will review the legislation to determine if our needs have yet been met. To date, we have not received those assurances. This is an issue of fundamental fairness, and we seek the opportunity to comment on this bill for your knowledge and awareness as the process moves forward. Reviewing consistency of local land use decisions with the Delta Plan should rely on the Delta Protection Commission's Resource Management Plan process. The DPC is the forum for coordinating local land use policies to protect the Delta, and this forum should not be superseded by the Delta Stewardship Council. We offer these few points in the spirit of wanting viable long-term solutions to save the Delta and provide clean and reliable water for all of us. Thank you. On behalf of the 5 Delta counties, we remain a ready, willing, and capable partner on this important issue, and again, appreciate your time today.
Thank you to all the Delta supervisors here. We appreciate it.
Thank you.
And thanks for your indulgence, Jonathan. You're next.
No problem. Good morning, Jonathan Clay on behalf of the San Diego County Water Authority. Being that we are not an agency that is first in time, first in right, unfortunately that's not a privilege that we have. We're literally at the end of the pipeline. We're very sensitive to water supply reliability. Because of that, we are here today in support of SB 17X. The status quo does not work for us in terms of water supply reliability, and we need to move the ball forward. We think SB 17X does that, and we urge your support.
Thank you.
Good morning. Jonas Minton with the Planning and Conservation League. I'm not going to talk about specific provisions, but really outline 3 what we think are sort of fundamentals that are not yet adequately addressed. The first is the overallocation of water. Now, you heard this morning on Senator Steinberg's panel from Representative Westlands, and they are, of course, in the Bay Delta Conservation Plan. He said that their objective is to return the levels of exports from the Delta to what they were before the biological opinions. So they're going to want to go back to the high levels. You also heard from Senator Steinberg about his negotiations with upstream water agencies. And they say, well, water isn't going to come from us. It's got to come from somebody else. This bill package does not address that fundamental overallocation. The second problem you have is the exclusion of the Delta interests from really the true decision making. And let me just explain how this works in the real world. Let's assume the bill passes. What happens then? United, unified, strong, well-funded opposition from the Delta interests. The last time in California that a water project went through over much less objections than that was Owens Valley. Most recently, we could look at the experience of East Bay Municipal Utility District on a project less than 1/10 the size of this one. They fought local interests for 30 years before they finally came to an agreement on a project that's now being built. This process is not affording that opportunity. And lastly, you heard about the funding. This project, what is the project? Conveyance, $10 billion? Have we heard from all of the parties that they're going to pay their share of this? Plus the cost for restoration, the bond that you'll be hearing about, and local cost share. That's a piece that you haven't heard about yet. It is projected that local water rates will more than double to pay for the cost sharing for the bonds, along with their share of the $10 billion or so for conveyance. For those reasons, we just don't think you've nailed it yet. Thank you.
All right, thank you.
Mr. Chair, Madam Chair, committee members, my name is Barbara Berrigan-Perea, and I'm the campaign director for Restore the Delta. I represent over 4,000 supporters, primarily from the Delta, but from throughout the state. First, I would like to make a couple comments about former Senator Patrick Johnston's comments. I have had the privilege of working with him in San Joaquin County on local land use issues apart from the Restore the Delta campaign. And he and I share many of the same views and very much believe that in the 5 counties of the Delta there is a strong need for good regional planning. But with that said, one representative on a Delta Stewardship Council does not adequately represent the Delta community. We've never asked for a majority representation, but we have asked for adequate representation. His other comment about forget about the economics about the Delta, we feel is extremely flawed. In fact, we think it's one of the primary items that's been ignored over and over by this body and in consideration of other programs through the Bay Delta Conservation Plan and the Delta Vision process. The agriculture economy for the 5 counties within the Delta, when you put in the multiplier effects, is estimated to be over $3.5 billion per year. Add in another 3/4 $750 million a year for recreational fishing and marina activities, plus yachting, you're looking at a $5 billion a year economy. With the water losses to the state, you've also seen a significant hit on the coastal economies that are directly tied to the Delta in terms of employment for salmon fishing and revenues from that industry. To say that you can go forward and not take these items into account because they are directly tied to water quality and water quantity is really flawed and does not represent the interests of the people in the Delta. I just want to conclude real quickly with our concern, as expressed just right now by Jonas Minton, is that unless you deal with the 8.5 times overallocation of water in California, this package, with all its fine points, will not resolve the crisis in the Delta. Thank you.
Thank you.
Good morning. Richard Lyon on behalf of the state's home builders, the California Building Industry Association. We strongly support the co-equal goals, and we want to see a completed and finished product be successful. What brings our concern today is the way that land use actions in terms of covered actions are handled within the language that has just been released in Senate Bill 1. Our reading of the new language is that it provides an exemption for covered actions for those activities that are determined to be consistent with the Delta plan, but it doesn't cover those types of legitimate home building activities that are going on within the Delta, the secondary zone of the Delta. We're not talking about the primary zone, only the secondary zone, and those areas specifically of the secondary zone that are identified for growth, both now and in the future. The language in the bill does not adequately address those legitimate activities. We have offered language. We continue to stand by that language, and we continue to be very interested in getting this issue resolved. We agree completely that areas that are identified for restoration, for conservation, and for conveyance should be given extra scrutiny and should be subject to the consistency requirement. But on the other hand, and this is a matter of balance and certainty, for those areas within the secondary zone that have been identified for growth, both now and in the future, they should not be considered covered actions and subject to the consistency requirement. Thank you.
Thank you.
Thank you very much. My name is Ryan Becerra of Barkowitz, Cronic, and Shanahan. I am an attorney for a number of upstream water agencies that have been very active in negotiating and developing over many years innovative water agreements that balance water supplies and environmental interests. The two primary ones being the Yuba River Accord that Yuba County Water Agency has negotiated and implemented, and the Sacramento Area Water Forum Agreement that among our clients, cities of Roseville, City of Folsom, Sacramento Suburban Water District, and San Juan Water District are all parties to. And the problem with this bill is that it presents a serious possibility that all of those innovative local and regional management solutions will be undermined by Delta Solutions. And we can only look at the bill's language to understand this. When you look at the intent in 85001A, it says, resolving the crisis requires fundamental reorganization of the state's management of Delta watershed resources. When you assemble that intent with the language in 85086C1 that indicates that the very fundamental determination of Delta flow standards will be done in 9 months with no hearing, and that then later on in the bill, the Delta plan will incorporate that by 2012. It does not look like much of a process to make the fundamental determination of Delta flow criteria. You then look at some of the drafts of the Delta Vision Strategic Plan, the third draft in particular, which is the only indication of specific flow criteria that we've ever had in any of these processes. And the water demands from the Delta watershed to implement those criteria are hundreds of thousands of acre-feet a year. There simply is no place to find that water other than reducing Delta watershed diversions. There just isn't any place else to find all of that water. And so whatever language you have about water right protection, if you have an expedited process that doesn't allow for evidence to set delta flow criteria when combined with the intent to fundamentally reorganize the state's management of delta watershed resources, it does not look like a bill that protects upstream water users. Thank you.
All right, thank you.
Barry Nelson with the Natural Resources Defense Council, but I've been asked today to speak briefly on behalf of Defenders of Wildlife, the Audubon Society, and Trout Unlimited. Those three organizations have been very encouraged by the progress that's been made to date. They've been following this process closely. They're very hopeful of a final package that they and others can endorse. In particular, they've asked me to state that their final position will be strongly influenced by the final outcome that we've heard a little discussion regarding today about how existing legal and constitutional protections are handled in the final bill. Thank you.
Thank you.
Steve Evans, representing Friends of the River. We remain opposed to this bill. A number of issues that we've constantly and for the entire length of the debate here have expressed concerns about have not been addressed, including the folks on the Delta Stewardship Council. We believe it needs more Delta representation. Again, not a majority, but I really don't see how, say, 3 members of the Delta Council being from the Delta would create such a huge impediment to implementation. And secondly, we're concerned that the council, a majority of whom would be appointed by a governor who wants to build the largest peripheral canal possible, and that just is just a bad policy mistake on this body's part, I think. Also, the co-equal goals. This is a very CalFed style euphemism, and I think it's doomed, as CalFed would be or was in terms of implementation. The lowest common denominator definition of co-equal goals is that exporters get 50% of the Delta's water and the Delta gets 50%, and that's more water than is exported now. And then thirdly, and this is a new issue, there's a legislative digest attached to the end of the bill that implies or actually states outright that funding for the Delta Stewardship Council will come from Prop 84 and Prop 1E funds. These funds are already allocated. They're funding integrated regional management plans, urban water efficiency programs, in case of 1E, critical levee improvements and rebuildings and levee setbacks. What projects are going to go unfunded or underfunded because we're going to take millions out of these bonds to fund a Delta Stewardship Council that water users from the Delta should be funding instead. So that's raised an entirely new issue. Thank you.
Thank you.
Good morning. Leo Winternitz with the Nature Conservancy. So a conservation organization and a wildlife-friendly farmer of over 10,000 acres in the Delta, we're focused on Delta governance and reestablishment of ecosystem processes in the Delta. We believe this legislation will accomplish this through the development of a Delta Stewardship Council, a Delta Conservancy, an independent science board, and the development of Delta flow criteria by the State Water Resources Control Board. We recognize that this legislation represents a complex set of compromises, but this is also probably the most important water legislation in the last 30 years in this state, and we believe that it will substantially improve the status quo. So the Nature Conservancy supports this legislation, and we will continue to work with you to ensure its integrity. Thank you.
Thank you.
Good morning. John Woodling, Regional Water Authority, representing urban water providers in a 4-county Sacramento region. We are strongly in support of aggressive water efficiency measures. The conservation language in this bill, however, is inequitable, and it won't reach the 20% goal. There's just an illusion of flexibility in the bill. The first option, 20% mandated without regard for cost effectiveness, is really the option that most agencies will be forced to. However, the bill still maintains the 5% option, the get out of jail free card for Los Angeles, San Francisco, other major urban areas, which will mean the 20% goal can't be met. The fourth option that's been added, the DWR option, would not even require DWR to come up with that alternative. If they did, they'd be required to come up with 20% cumulative goal. Well, if 20% of the population only has to do 5%, the answer is inland areas have to do much more than 20 to reach that goal. So what we're left with is the 20% option without regard to cost effectiveness and without regard to where the benefits would flow and who would pay for the cost of that. Thank you.
Thank you.
Members of the committee, Kathy Mannion with the Regional Council of Rural Counties. Appreciate the opportunity. I'll be very brief. We will be submitting more detailed written comments. I'd like to just comment on 3 issues. First, it's already been mentioned, the groundwater county connection. I've sent the language out to my member counties and will be providing you with information as to their response. But I would say that just like in anything, one size does not fit all, and I think that's what we'll be coming back to you with. I'd like to associate ourselves with the comments that was made by Ryan Becerra on the points that he touched on. And then the last issue I'd like to address is the area of origin language that is in the bill, the draft bill. As you may know, we've been expressing concerns with language in the draft water bond. I've asked our attorney to look at the language in the bill, and he says that essentially the language confirms that the new legislation will not alter existing water rights law, including area of origin, and that the language protects all water rights. He also notes that there's other changes in water right and water transfer sections that are not specifically referenced in the bill, and those are Water Code sections 1725 to 1732 dealing with temporary changes, and 1735 1737 dealing with long-term transfers, so I bring that to your attention. And the bottom line is that we find this language is much better than the previously referenced language that added conflicting proportionality priority directives. Thank you.
Thank you.
Thank you, Mr. Chairman. John Herrick, South Delta Water Agency. As I've said before, the issue of reliable supply for the state of California is the underlying problem here. And if the original estimates by the Department of Water Resources were correct, we're 8 million acre feet short in a repetition of the 28 to 34 drought each year in the watersheds. That 8 million acre foot shortage was supposed to be supplemented by 5 million extra acre feet to the system. That wasn't done. So until you can define what you mean by reliable supply, you certainly shouldn't make it a goal which is co-equal to protection or restoration of the delta. There isn't the water available. The bill proposes to make in-stream flow determinations by the state board on a very, very short-term basis, but there's no consideration for where that's going to come from. Let's all assume that we need additional flow on the various tributaries and in the delta. Where is that going to come from? It's going to come from the upstream users or in-delta users. And why do I say that? Because the bill appoints a water master and gives the state board 25 additional people to get all of us illegal diverters in the delta, right? There's this assumption going on that there's this vast number of illegal diverters, and if we just ratchet them down, we'll have more supply. Well, even if we shut off the delta, that's not going to supply the water we need. You should ask the Bureau to show up and give you its analysis of why it allocated 0% to ag this last February before the rains. It wasn't that it was going to have interrupted pumping in the future. There wasn't any water behind the dams for them to do deliveries. There was water for other purposes, but not for that. Now let me just end with the issue of conservation. We've all heard this before. Conservation is good in many places. If you mandate conservation on the San Joaquin River, let's just say the urban areas decrease their discharge in the river by 400 CFS, or the ag people in combination of that. This summer we would have had 100 CFS in the San Joaquin River. You have to think through the consequences when you just blanketly say things like conservation is good. It's not good in some places. Who's going to put the water in the river if conservation makes the river zero? Someone else. Thank you very much.
Thank you.
Thank you, Madam Chair, Mr. Chair, members of the committee. I'm Ron Davis with the Association of California Water Agencies. I would certainly like to begin by indicating that ACWA is very appreciative of all the time and energy that the members of both these committees and the legislative leadership, the author of this bill, have put into this effort. It's a major, major multi-level chessboard that we've all been working on, and we are very grateful for the time, energy, and commitment that you've shown thus far. On behalf of ACWA, I will say that while we see substantial improvement in SB 1 over SB 68 draft that came out on September 11th, we do still have areas that we would like to continue working on. In particular, I'll just highlight a couple of them real quickly in a short period of time. In the area of water rights enforcement, we are working with our upstream folks on trying to address the concerns that were mentioned to you by Mr. Ryan Becerra a few moments ago. And highlighting one in particular, we are still concerned about the language that would authorize the State Water Resources Control Board the power to initiate determination of rights under their own motion. There is a couple of new fees that we would like to work with the proponents with. And in the area of conservation, we would like to work with the authors on the conservation language, and particularly on the fourth option, to try to address some flexibility for those who would like to exercise that option along the lines that Mr. Woodling mentioned a moment ago. And wanted to let you know that we are working on some cleanup language on the waste and unreasonable use provisions in 1011. Those are quick highlights. We will have written comments for your benefit as soon as we can put them together. Thank you very much.
Thank you, Mr. Davis.
Good morning, perhaps good afternoon, Madam Chair, Mr. Chair, committee members. My name is Dan Kelly. I'm with the firm of Somax, Simmons & Dunn, here today on behalf of the Northern California Water Association, or NCWA. NCWA appreciates the positive steps that have been taken in improving this legislation. This version of the bill is definitely, we think, an improvement over prior versions, and we definitely support the continued effort to reach consensus on the bill language. NCWA has been proactive in trying to improve and assist in developing both water use efficiency language and groundwater monitoring language, particularly as it relates to AB 900, and we look forward to continue to doing that. We do still have some concerns with the bill language. Some of those provisions have been discussed already. Specifically, we are concerned about allowing the Water Board to self-initiate water right adjudications. Water right adjudications are controversies among parties. It's a way of resolving those if there's not a controversy. It creates significant expense to force people to resolve controversies that they don't think that they have. We're also concerned about some of the flow language and the process by which those flows will be determined. We agree with the comments by Ryan Becerra that it needs to be a more rigorous evidentiary proceeding. Currently, the bill anticipates an informational hearing at the Water Board that doesn't allow for rigorous cross-examination and questioning and testing of evidence, and we think that that needs to take place. Our biggest concern perhaps is the water right priority issue and area of origin protections. And water right priorities are probably the most longstanding principle of California water law. Certainly predates the constitutional amendment on reasonable and beneficial use, and we feel that it's necessary to protect water right priorities. Some of the comments at today's hearing confirms the concerns that we have, and I'll say some of the area of origin protections are recognized through the Watershed Protection Act, and that resulted in state-filed applications for areas in the area of origin. And the thing that makes those so valuable is their senior priority date. They have a 1928 priority. They were set aside for the areas of origin. And if you undermine priorities, then those area of origin protections get significantly diminished, notwithstanding the language in the bill. We look forward to participating in the process as it moves forward. Those are some of our concerns.
Thank you.
Thanks.
Thank you, Madam Chair, Mr. Chair. My name is Rob Roscoe. I'm with Sacramento Suburban Water District. We represent about 44,000 connections, 100,000 people in the suburban Sacramento area. I'd like to point out our district has invested very heavily, over $100 million of local investment in conjunctive use projects so we can get off of the American River in dry times. and pump groundwater, but we still have a sustainable groundwater basin, and we go to the river in wet times. We have a great investment in complying with the water form agreement you heard earlier. There was an 8-year negotiated settlement with co-equal objectives of protecting the environment in the Lower American River and safe and reliable water supply. So my concern here is I don't want you guys to increase water reliability for others in the state at the expense of water reliability for those in the upstream areas. We have invested very heavily in that system, and we wouldn't want that whole system of water supply eroded. We are fully complying with the water form water conservation element that we negotiated, and that was a landmark agreement. And I'm just wondering why, when we look at doing water conservation in the future of the state of California, there isn't specific requirements that we look at the energy impacts of that water conservation. It was mentioned earlier in testimony about our greenhouse gas initiatives in California and how we do that. Pumping water takes a lot of energy, and there's a reason, if you have to lift water over 2,000 foot of a mountain range, why it is cost effective to do conservation. The energy cost is very expensive, and I don't see that referenced anywhere in the legislation. I appreciate the comments that I heard from Mr. Becerra earlier, and I fully endorse all of those. And with that, I thank you for your time.
Thank you.
Thank you, Chairs Pavley and Huffman and members. Danny Merkley with the California Farm Bureau. We are very pleased with the progress that we've seen, particularly in recent weeks, and the hard work by everyone on all sides working on this. We have some remaining concerns, particularly in the area of water use efficiency and in surface water reporting. We will put those in writing so that I'm brief here today and get those to you in very short order. I heard several people mention the real world today, and I would just suggest to you that those that are out there producing a reliable food supply with an unreliable water supply and unpredictable weather are really those in the real world. So thank you for your time.
Thank you.
Chairs and committee members, I'm Valerie Nera for the California Chamber of Commerce. SB 1 is certainly an improvement over SB 68, and we appreciate the time and effort it's taken to get to this point. Though it's much better, there are still a few hiccups that need to be worked out, especially in water conservation, in water rights, and in water use efficiencies. We have put forward some language to you covering those areas before, and be happy to do it again and wish to work with you. Thank you.
Chairs and committee members, my name is Gertie Candres. I'm a resident of San Joaquin County, and I would like to know where is our representation of San Joaquin County on this committee? I don't see anyone raising their hand. Ms. Volk, I do agree with your comments. However, I believe Allison Huber represents us.
She's been sitting here the whole hearing, but we have a session on the floor of the State Assembly that started 12 minutes ago.
Okay.
So
anyway, I want to let you know what the people in San Joaquin County think, and we've recently updated our general plan. And the reason I'm here and not my neighbors also is because they're working and they cannot be here. But our number one concern when we updated the general plan, and you can go online and look at it, you're very welcome to, I come from Woodbridge, was the peripheral canal. You are telling about illegal diversion of water. It is illegal diversion of water. We are not represented adequately on this committee. Our farmers need the water, and they need to be represented. Now, on page 2 of this document, it says that this legislation is to advance environmental protection and the economic well-being of Delta residents. None of us see it this way, and I wanted you to be aware of it. Thank you very much.
thank you.
Tim Parker, Chairman of the Legislative Committee, Groundwater Resource Association of California. And GRA is the nation's largest state organization of groundwater professionals, representing about 1,400 people. We support resource management that protects and improves groundwater. We support data monitoring. Data's good, monitoring's good, data transparency is even better. We support specifically and explicitly the monitoring provisions of the bill. We want to thank the members and their staff over the years for getting to this point. We realize it's a small step, but a step in the right direction. Thank you.
Thank you. Next, please.
Hello, Sylvia Solis Shaw on behalf of the Contra Costa Water District. The district appreciates the changes that have been made to address the district's interest to achieve a robust delta with high quality water and a restored ecosystem. The district can in fact support the policy bill, but urges the legislature to develop the financing plan and address any issues that remain from other delta parties. Thank you.
Great. Thank you for your support.
Thank you, Mr. Chair. My name is Michael Green. I represent the California State Grange. The Grange is comprised of approximately 180 local granges located in small towns and rural farming areas of California with over 9,000 members. The Grange has been active in California public policy making since 1872 and successfully conducted its 137th annual meeting earlier this month. Per resolutions adopted at that meeting, the Grange endorses the recommendations of the CalFed Bay Delta Program and the Delta Blue Ribbon Task Force and supports passage of Senate Bill 1X7 as it may be improved. The Grange believes that the recommendations of the Delta Blue Ribbon Task Force Delta's Vision Strategic Plan offer a comprehensive and integrated guide to solving California's immediate water problems. The Grange also believes that the use of the Tulare Lake Basin for above and below surface water storage should be given serious consideration as part of the overall solution to our state's water problems, and the Grange commits to work for preparation of a study of the feasibility of the use of the Tulare Lake Basin as a surface and groundwater storage hub with river and canal interties. We believe use of the Tulare Lake Basin for surface and groundwater storage with correct mechanism and incentives will move the San Joaquin Valley towards regional self-sufficiency by reducing the west side of the valley's dependence on Delta water. In this area of federal and state and local budget deficits and competing demands for infinite financial resources, this is the most prudent and cost-effective approach to solving one of California's most pressing problems. Thank you very much.
Thank you. Nice to hear somebody reference my favorite new surface storage project, Tulare Lake.
Good afternoon. I'm Steve Wallach here on behalf of the Alameda County Board of Supervisors. They're seeking amendments to the Delta Conservation composition to include an appointee from the Alameda County Board of Supervisors. The jurisdiction of the Conservancy includes Alameda County, yet it's the only county without representation on the board, and we urge you to consider those changes. Thanks.
They should have
Good afternoon, Chairman Huffman, Chair Pavley. Mark Thiessen with the Gualco Group on behalf of the Alameda County Flood Control and Water Conservation District, Zone 7. Very briefly, Zone 7 provides water at the wholesale level to 425 square miles of eastern Alameda County, also provides flood protection and supplies water to the agricultural industry in that particular area of our state, primarily viticulture. I want to associate myself and Zone 7 with the remarks of Mr. Wallach and build on the 4 pieces of correspondence that we've previously sent the members, and of course testimony and private meetings with regard to this issue. And just make one additional point. It's been common that the Delta counties have been commonly referred to as the 5 Delta counties. We have been arguing at least since March that there are 6 Delta counties, and you have to look no less to the bill to verify that particular fact. In SB 1, indeed, all prior iterations of the legislation, certainly Ms. Woke's SB 458, define the Delta per Water Code Section 12222, and in that Water Code section, Alameda County is specifically referenced. So we would argue that because the Delta, the legal definition of the Delta certainly includes Alameda County, The significant and far-reaching decisions that will be made require a representative of Alameda County to serve on the Conservancy Board. Thank you very much.
Good afternoon. I'm Marlene Dumaine, and I'm with the East Bay Municipal Utility District. I want to start by thanking Chairman Huffman and staff for working with us over the past week to move towards addressing our concerns. We think that SB 1 is vastly improved over SB 68. We still have a few concerns with the bill, and in particular mirror the comments made by Ryan Becerra and NACWA regarding the need for an evidence-based process as the State Board completes its in-stream flow determinations. We hope that we will continue to have the opportunity to work with you on our concerns, and thank you.
Thank you.
Committee chairs and members, my name is Jim Metropolis. I represent the Sierra Club. We are opposed to SB 68 or SB 17XX. We have numerous concerns which we've stated, but I'll highlight some of them for you today. First of all, we're somewhat concerned with what amendments were taken to remove or gather the support of the SFPUC. We have seen documents which provided for 5 or 6 amendments, which actually would take what we think a bad bill and make it much worse with regards to the flow determinations and how that's determined for the BDCP process. There was also language in there to say, hey, if we need more water from the Delta, you're not getting it from SFPUC. And so where is it that we're all in this together and everyone has to take part in fixing the Delta? So we're curious to see those amendments that got the SFPUC in a support position. We continue to hammer on and say that there's numerous flaws in the package. With regards to the Delta Stewardship Council, here you have a council which once again has no ability or power to reduce exports from the Delta. We think that that is a specific power that this council needs to have. Furthermore, it has no authority to set fees. This is not like AB 32, which gave specific fee authority to CARB to provide for mitigation. That's not in here at all. There's still no qualifications on who sits on this board outside of the chair of the Delta Protection Committee. There is token Delta representation, and now we're giving terms, and some people on this council will now sit there for 6 years and be appointed by a governor that has 1 year left on his term. I don't know who the next governor will be, but at least water is part of the debate, and I'd rather see someone that has a mandate from the people moving forward with something new than giving so much authority in appointing people to this council to the current governor. Once again, the conservation part is very problematic. You have this stated that it's 20 by 2020, but we don't see how, when you read the mechanisms of the bill, how that will happen. And so where we hear the term, all of a sudden, greater flexibility, we see, when we read it, further weakening. We see now that there's a fourth way to comply, that DWR will somehow set up a process and there'll be a fourth way to comply with this 20 by 2020. Many water agencies and cities still will fall under this 5% threshold where they only have to do 5% conservation, not 20%. We've asked you for, well, who are these water agencies? We've asked for this list. That information still not out there for the public to see as to who is actually going to do 20% conservation, who is actually going to do 5% conservation. We would love to see that information. As someone mentioned, no enforcement, all carrot, no stick. That was one of the panelists who also said that the agricultural sector uses 75% of the water in this state. They are not asked to reduce 1% in this bill. They're only here to do plans. We see this bill actually, moving in a bad direction, and it's a little like, rearranging deck chairs on the Titanic. We certainly appreciate having a hearing, seeing language 2 days before, so at least we see a little better process playing at hand here. Thank you.
Thank you.
Good afternoon. My name is Debbie Davis with the Environmental Justice Coalition for Water.
I'm going to get straight to the point. I think one of the weakest links in this package, and it has been from the beginning, is the funding element. The package, or the bill as it stands, as it was released on Friday, suggests that money will be taken out of the Integrated Regional Water Management Planning Program for the Two Gates project. That's $28 million, and that DWR will use that fund to supplement the cost of operating the groundwater program. And then at the end of the bill, it says it's the legislative intent that Props 1E and Prop 84 will fund the council's process. I suspect that it's the intent of the legislature, not an enactment of the legislature, because it may not be consistent with the will of the voters. And so again, we have a bill that has many large aspirations and not a whole lot of money to fund it, except for money that will come out of other sources and other pots. And this is particularly of concern to environmental justice communities, because so often when these last minute cuts are forced to be made, they come out of the funds that go to fund our projects and programs. My second and last point is that I just want to say a little bit more about the unintended consequence in the groundwater monitoring program that's now been made voluntary and where the counties have been made the backstop. If the counties do not comply ultimately and no one else in a county complies, then those counties are disallowed from receiving state funds for water, whether it's an administered program, which means federal funding, or whether it's an actual grant program of the state. And we expect that some of those counties that have large numbers of communities without safe drinking water will be at the top of the list that will suddenly become ineligible, which will have catastrophic consequences in those communities. So those two are two additional unfortunate elements to this plan, and we think ultimately, again, we need to take a step back and we really need to ask ourselves, how do we, in an efficient and sustainable and equitable way, meet California's water needs? Thank you.
Thank you.
Mr. Chairman, Martha Guzman with the California Rural Legal Assistance Foundation. We did submit some writing, a letter outlining some of our larger concerns with the package, and some include financing pieces, including a polluter pays proposal for communities, and also some other elements. And I just want to catch on two today that were touched briefly upon, because again, what we tried to capture in this letter is how this package and how water policy reform could improve the lives of farm workers in rural communities, as we've heard a lot about in the past few years, particularly the drought situation on the west side. And there are a couple of proposals that we think should be included in this language to ensure that further economic impacts, not just to the west side, but all communities dependent on contracted water, should have in place. At one point, there was a degree of this in the package, but has been eliminated. We do think that there should be the development of a drought and disaster contingency planning for South Delta agricultural contractors, and that those contingency plans should include transition assistance for farm workers during all of those different scenarios. We also agree that local governments should play a bigger role, and in particular, local governments should have a voice in restricting the right of contractors to resell their water out of the valley, especially when unemployment exceeds whatever threshold we can talk about. We would propose a threshold of 50%, or that the surrounding community lacks access to safe drinking water. Both of those are areas where we think a local government should in fact engage. What we have seen traditionally on the west side is a lot of reselling, a lot of land retirement, voluntary land retirement programs, a lot of different ways to deal with the salinity problem on the west side. And unfortunately, there has never been a comprehensive way to include communities and workers in that solution. We think supply is important, but it is not the only piece. And again, we have different components that we've proposed in our letter dealing with other sustainable management practices, dealing with the salinity problem in particular, and the nitrate problem, obviously the biggest groundwater problem in the state, and particularly in our communities. And finally, I just wanted to reiterate some of our concerns.
We need to wrap it up, Ms. Guzman.
Okay, just to reiterate the concerns that were stated in terms of the groundwater piece and giving counties the jurisdiction. We would at least request that disadvantaged community drinking water and wastewater programs be exempted from that ineligibility of funding, because we do have the fear that certain counties where our communities have this need would then lose out of critical state and federal funding.
My name is Tom Zuckerman. I'm one of the Delta representatives here, currently representing the Central Delta Water Agency. I think the basic problem you're dealing with here is the legislation fails to solve the water supply issues. It dances all around them. It engages in a sort of a 21st century alchemy, I think, to try to make water out of something. I'm not exactly sure. But until we come to grips with the fact that this system is woefully short of water and figure out ways of not just reallocating shortages, but try to meet some of these needs, we're not going to solve these problems. Certainly the people in the Delta who are uncomfortable with 2-minute snippets at the ends of hearings instead of being involved in these discussions by the legislative leadership remain solidly opposed to this. And somebody predicted a little bit earlier on that you're just sort of choosing off a big fight. I think he was right. Thank you.
Hi, Melinda Terry, North Delta Water Agency, and I'm going to read from an article that was November 2008 that says, after receiving the proposed amendments, the third parties identified 4 areas of impact, including protection of water rights, prevention of seepage impacts to lands adjacent to the river, additional fish barriers, and no introduction of anadromous fish until mitigations are completed. And this was last year, and this was requested and put into the congressional legislation on the San Joaquin River settlement. It was requested by the San Joaquin River Exchange Contractors Water Authority. And my point is, I think it is doable. The feds managed to do it. They got it in their federal legislation, and according to an article last week, they are continuing to negotiate some individual agreements with these folks. As you know, our agency also was successful in negotiating a water rights and quality and supply contract in 1981. So I do think it's possible, but things have changed since 1981. When our agency did the contract, the fisheries were healthy. But now they're not, and so the plans that are out there, whether it's the Delta Conservancy that's created, the BDCP, the Delta Vision, out of our 277,000 acres, about, at least under BDCP, about 50,000 aquatic acres have to be created, which means you're converting existing terrestrial habitat to aquatic. So now you got to go find some other terrestrial acres. So the acreage issue is really significant. And we don't believe, obviously doing the contract, we're not about standing in the way of moving forward with a water solution. We do think solutions are there, and we'd like to be part of it, but we do want to stand up for the rights that exist. And these issues are real. Last week, also, there was an article about City of Council of Novato that's dealing with a coastal conservancy aquatic habitat wetlands that now that they started filling it with water, it's seeping and flooding out the residential homes next door. So these issues are real, but need to be addressed up front, because the City of Novato now is going to have to pay for it and hope they can find somebody to pay them back from Coastal Conservancy. I heard the bell, so I'll just say finally, I noticed that the bill still says the Delta Stewardship Council will meet once a month, and that at least 2 hearings have to be in the Delta. Again, when you think about the acreage that is being asked to be changed and dealt with in new ways, how are these people from Walnut Grove, Clarksburg, West Sacramento, are they supposed to travel to San Diego, Los Angeles, Riverside, I don't know, Palm Springs? It just does not seem right for that either. Thank you.
Thank you. Our last public
but not least
voice.
Yes.
Welcome, Steve.
My name is Steve Hayes, and I'm representing the Sierra Resource Conservation District of Eastern Fresno County, as well as the San Joaquin Valley Leadership Forum. My comments are directed towards groundwater elevation monitoring legislation. My understanding with AB 3030 was the first legislation that was required for counties to come up with groundwater management plans. And this is a good step forward because of groundwater depletion, especially in the San Joaquin Valley, where it's estimated 63 million acre-feet of groundwater has been depleted over the last 45 years. However, the legislation as intended is limited just to the valley floor, and there's been a lot of growth, as you know, up into the foothill and mountain areas of the Sierra Nevada, and as well as in other parts of California, in which groundwater depletion is a big issue as well. And if I recall correctly, Senator Costa, when he served in the California State Legislature, looked at communities such as Oakhurst, where a population of 10,000, their wells are in bedrock down to 1,400 feet now, believe it or not. And, you know, that compares to wells on the west side being well over 1,000 up to 2,000 feet in depth. The amount of water available is very limited to the fractures, and I would propose that there be some type of language to expand this as well. We've been very fortunate because Fresno County, as well as DWR out of Fresno, has seen this issue, and I'm certain it's not just unique to eastern Fresno County. Thank you very much.
All right, and thank you, everyone. We are going to adjourn this informational hearing, and I expect there to be a file notice very soon. Tentatively think about Wednesday as our next hearing, where we're going to take up the issues of financing. Senator Pavley, did you want to close with anything?
No, I just wanted to thank you, Co-Chair Huffman, for putting this informational hearing together. Particularly of interest to me, of course, was on the water rights and groundwater monitoring and the need for that, especially with groundwater being about 30% of our water supply, and in tough years, 40 to 50%. So I appreciate the people that came today and took the time to testify. As always, feel free to submit information in writing. The purpose of Wednesday's hearing tentatively will be on financing and the bond.
Thank you.
Thank you.